Let's go live button. So now we're waiting for the stream to fire up across the internet. Then we're going to get right into the program because we've got a lot of legal news we got to talk about today. So let's make sure the stream is alive and well, and it looks like it is. So let's get started. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in a little thing called justice. And it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and I to follow, but sometimes have a little bit of difficulty doing so themselves. And so that's why we started this show called Watching the Watchers, so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency back down upon our very system with the hope of encouraging some meaningful change. And we're very excited that you are here and with us today. We're back. It's Monday. We're ready to get rocking and rolling here. We're going to be talking a lot about some changes going on in our judicial system, our justice system in particular. We're talking about the Senate Judiciary Committee. They're having confirmation hearings today for Merrick Garland, who is the nominee for the U.S. Attorney General's position. And so that is a big job. That is a big deal. And we want to go through that with a little bit more detail to show you who Merrick Garland is. We've heard this name before. You may remember him from back during the Obama years. In fact, he was supposed to be somebody who was going to be nominated up to the Supreme Court. We'll get into that. We want to do a quick refresher on his background and then go through his opening statement a little bit today. He actually gave this formal written opening statement, and we've got some things that we can pull out of there. This is basically the chief law enforcement officer for the entire country. So we want to dive into that and learn a little bit more about what he is going to be doing, presuming that he does get the nomination, and I think that he probably will, or that he does in fact get confirmed. Then we're going to change gears a little bit. Over the weekend, actually, I think early today, there was a new slew of orders that came out from the Supreme Court of the United States in preparation for their upcoming session. And we have some cases that were granted certiorari. We have some cases that were denied. And we want to break down what is going on there because there's a very interesting dissent that came out from Justice Thomas sort of over this Pennsylvania election case. We spent a lot of time on this channel talking about that particular case, and it has been sitting in front of the Supreme Court for a very long time, and they denied that. So we're going to get into that and what that means. Then we're going to talk about this new lawsuit against the MyPillow CEO, Mike Lindell. He is being sued by Dominion for $1.3 billion, another big billion-dollar lawsuit. We've seen this happen against Sidney Powell. I think Lynn Wood may have one floating around there. Certainly Fox News does. And so this is kind of another one in the same vein, but we want to go through that because it is a big lawsuit. Then we've got a couple sort of leftover stories, not massive stories. We're going to spend a little time on them, though. One, in Arizona, there are whistleblowers now from our from our state prisons who are saying that the prisons are not letting people out even though it's their release date. So, in other words, they've served their time and they're not being let out of custody. And I want to explain what is going on with that. And then there's another bill that is being proposed by an Oklahoma representative by the name of Kevin McDougal that is essentially allowing people, or would allow people, to just go ahead and run right over those protesters in the street. So if people are protesting and you just, you feel unsafe, you can just kind of barrel through them with no criminal repercussions for that. So very interesting. It's a little bit more complicated than that, all right? It's not the run over the protesters bill, but that's how I like to call it. So let's get all into it. Before we do, want to give you a quick reminder to head on over to locals.com/watching the watchers if you have a question for the show. So I'm going to go through some slides. We're going to go through those different stories I just outlined. At the end of each segment, if you want to ask questions, or as I'm going through the segment, if you have a question, feel free to send that over to Miss Faith in the live chat show that takes place over on locals.com/watching the watcher. Since we've been demonetized on YouTube, we're taking questions over there just to have a little bit better flow of the questions. And so she'll be capturing those, and she'll be interspersing those throughout the proceeding. Also, throughout the proceeding, I'm not in court. This is a live stream. So throughout the live stream, she'll be interspersing those questions. We'll also be putting a copy of the slides up on Watching the Watchers Locals page, as well as you can get a copy of my book, copy of the existence systems, the impeachment party templates, a lot of good stuff over there, including good conversation. So head on over to Locals. youtube.com/watching the watchers to join in. All right, so let's get into the news. The first story, the big story of the day, is about Merrick Garland. So Merrick Garland is now up for nomination. He has been nominated, and the Senate Judiciary Committee is going through their formal process where they are going to be asking him questions, holding a hearing, advice and consent of the Senate to confirm him into Joe Biden's cabinet position. And so before we start talking about Merrick Garland specifically, I want to flesh out this position, the Attorney General of the United States, because if you're a lawyer, you kind of know what this is. But if you're a non-lawyer, if you're somebody that doesn't kind of exist in this space, then you may not know exactly what they do. We have so many different agencies in this country now. We've got, Office of Inspector General, Office of Legal Counsel. We've got, the Attorney General. Then we've got the Solicitor General. And you've got all these different sort of legal-ish types of divisions within our government. It's hard to make sense of who does what and when and how do they do it. So let's learn a little bit more about the Attorney General of the United States. And I'm just going right off of Wikipedia here, and then we're going to look to the Department of Justice itself just to educate ourselves. And we're not going to spend a ton of time on this. According to Wikipedia, the United States Attorney General leads the Department of Justice. So the Department of Justice, it is a massive entity in the U.S., and the Attorney General is the chief lawyer of the federal government of the United States, okay? And so you can't really even wrap your head around how big of a job that is. The entire United States, okay? If you got in trouble for, DUI or shoplifting, stealing a candy bar, you would go hire a lawyer for you against the government. This is the government. This is the main lawyer for the entire federal government. 350 plus, 70 plus million people here, right? It's a big, big job, a lot of oversight. Back to Wikipedia, it says that the Attorney General serves as the principal advisor to the President of the United States on all legal matters. The Attorney General is a statutory member of the Cabinet of the United States. Under the Appointments Clause of the U.S. Constitution, the office holder is nominated by the President, then appointed with the advice and consent of the United States Senate, and then the Attorney General is supported by the Office of the Attorney General, which includes the executive staff and several deputies. And so we're right in this process right now. Merrick Garland is the current candidate who is, and so Wikipedia even says this, Monty Wilkinson is the current acting U.S. Attorney General since Joe Biden took office. He's expecting to serve as the acting Attorney General until Biden's nominee, Judge Merrick Garland, is confirmed by the United States Senate. So we're right in the middle of that process right now. Today was the first day of those hearings. We have some clips from Merrick Garland, some that I think are interesting. So what we're trying to do here in these confirmations hearings is just sort of, peel back the layers of the onion on this individual in particular and say, what is your philosophy going forward as the chief lawyer of this country? There are a lot of legal issues that we deal with on a regular basis. In fact, this show talks about most of them, but there are many that we do not talk about. And so you're trying to sort of glean in these interviews, what is his philosophy? What is he going to do? Is he going to be, focused on any particular issues? What is the due process type of mindset that this individual has? Where do they stand on certain fundamental issues like the constitutional rights and things like that? How do they interpret the Constitution? A lot of very important questions that are going to touch everybody in this country one way or another, because the law goes everywhere, right? And we all know that. So this is what the org chart looks like over at the Department of Justice. Massive entity, as I said. So you have the AG up here at the top. You've got the Deputy Attorney General down below, and then just a whole slew of other agencies. And I wanted to just call your attention to some of them. So, of course, we have the Civil Rights Division. We hear some of that today. We've got a tax division from the U.S. Attorney's Office, the Attorney General, which we have. Let's see what else we've got. The Office of the Solicitor General, and then we've got some of the major enforcement agencies that are all under sort of the stewardship of the Attorney General. You've got the FBI, the Federal Bureau of Investigation. You have the Criminal Division of the U.S. Attorneys. You've got the Bureau of Prisons, the U.S. Marshals Service. We have Interpol in Washington, the U.S. Attorney's Office. We got ATF, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the Executive Office for U.S. Attorneys. We got the DEA, the Drug Enforcement Agency. And so it just goes on and on and on. And you can see just how expansive this entity is. It's massive. It encompasses a lot. And so Judge Merrick Garland, he's the person who's going forward right now to be to determine if we can confirm him or not. We'll see what the senators want to do. A little history here. Congress passed the Judiciary Act 1789, which established the office of the Attorney General. Original duties were to prosecute and conduct all suits in the Supreme Court in which the United States shall be concerned, and to give his advice and opinion on questions of law when required by the President of the United States or when requested by the heads of departments. Some of these duties have been transferred over into the U.S. Solicitor General and the White House Counsel. DOJ, the Department of Justice, was established 1870 to support the Attorney General and the discharge of their duties. The Attorney General, Secretary of State, Secretary of Treasury, and the Secretary of Defense are regarded as the four most important cabinet officials in the United States because of their size and importance of their respective departments. And then Wikipedia gives us a little bit of an interesting tidbit here. So if you have multiple attorneys general, that's the proper way to say it. So it's not we have a whole lot of attorney generals with a plural at the end of generals. It's attorneys general. So when we had, I don't know, what was it? 12, 16 attorneys general sign onto that lawsuit that Ted Cruz was supporting around the 2020 election litigation that went up to the Supreme Court. Some people were saying, well, 20 attorney generals signed it. No, it was actually 20 attorneys general. Just a little bit of a fun fact right there. And so you can see massive Secretary of State, Secretary of Treasury, Secretary of Defense, the Attorney General. Big position. And these were the prior attorneys generals. Attorneys general are on this slide right here. See, I did it myself. We have, of course, in recent memory, Bill Barr. And if you don't know this, Bill Barr actually had served previously as the Attorney General from 1991 to 1993. You may remember Janet Reno from, I think those were the Waco days. We got John Ashcroft. We got Alberto Gonzalez during the Bush years. Then we get over to Obama. We got Michael Mukasey. Don't know how to say that last name. And then Eric Holder was a very long-running attorney general during the Obama years, 2009 to 2015. And then the last 2 years of Obama, we had Loretta Lynch before we got Jeff Sessions very briefly. Then we got Bill Barr. And now we're contemplating who's coming up next. And so it sounds like it's going to be this guy by the name of Merrick Garland. And so he is a former chief judge of the United States Court of Appeals for the D.C. Circuit. So he's been in D.C., been a former chief judge from the Court of Appeals for this position. He's an American attorney. He's a jurist. He serves as the circuit judge for the Court of Appeals in D.C. on that court since 1997, and he was nominated to be the U.S. Attorney General. 68 years old right now. Married, went to Harvard Law School, went to Harvard College, and then went to Niles West High School. He's got 2 siblings. A little bit more about him. It looks like he was a native of Chicago, and he attended Harvard. He was a law clerk in the Second Circuit Court of Appeals, and then to the Judge Brennan in the Supreme Court of the United States. So a lot of corporate litigation, it sounds like. And then he was involved at the U.S. Department of Justice, prosecuting the Oklahoma City bombers. Right, and then this paragraph here on Wikipedia goes through some of the background on where he came from, and so this was actually something that was very controversial back during about 2016. If you recall, there was a judge by the name of Judge Scalia, one of my favorite judges, very interesting judge to read, very provocative, very sort of aggressive opinion, somebody who would come out and just use language beautifully. Now, a lot of people on, I would say, sort of the left wing of the judicial philosophy, the left wing of the courts, a lot of people who think more in the lines of sort of active liberty versus constitutional and I would say interpretation, textualism, which is where Scalia was. They don't like that. They don't like Scalia at all. And so what happened back in March of 2016 is Scalia died unexpectedly and sort of just very, very suddenly. And this was a moment in time when Democrats largely thought that the balance of the court might be able to sort of flip or start reverting back towards the left because Scalia had passed. Obama was the president. He would get to nominate somebody else, and they were going to nominate, of course, a Democratic left-ish judge, and that was Merrick Garland. But unfortunately for Merrick Garland, the problem there was that the Republicans held the Senate, and so Mitch McConnell basically just didn't hold a vote on whether or not to confirm him. And so this goes through that in a little bit more detail. It says President Barack Obama, a Democrat, nominated Garland to serve as the Associate Justice of the Supreme Court March 2016 after Scalia died. Republicans said that Garland was an acceptable choice, but then the Senate Republican majority refused to hold a hearing during the last year of Obama's presidency. And so Wikipedia, they of course call this an unprecedented refusal, and they're very aggressive, sort of it's pejorative against the Republicans. But eventually, nothing happened there. Garland's nomination lasted 293 days because Mitch McConnell didn't hold a vote on it. That nomination expired. They were presuming, of course, that Hillary Clinton was going to win. She didn't. So then, Donald Trump won and then eventually nominated Neil Gorsuch, who is now on the court. And so Merrick Garland was somebody who was kind of in an alternative universe, could have been on the Supreme Court. Had Hillary Clinton won, they probably would have had no choice but to confirm him, but that didn't happen. And so now he's back. He's back to be the Attorney General. And we've got a little bit of some information about the hearing that took place today. This came over from Law and Crime Today. The confirmation of Judge Garland never got from the Senate roughly half a decade ago. It has finally arrived with a twist. Now, instead of aspiring to be the Supreme Court judge, he is now wanting to be the top prosecutor in the United States, a role that left him to release a statement reflecting on the Department of Justice in a career that began encountering extremism. So we're going to get into his opening statement right now. Throughout the proceedings today, according to this article, Democrats sought to contrast Garland as an antidote to the prior administration attack on the Justice Department's independence, turning the page from a former president, Donald Trump's loyalists like ex-Attorney General Bill Barr, with a judge widely praised by both parties. So we're going to get into this. Let's take a look at his opening statement. As I said, I like to read some of the primary sources on this. Largely what you're going to hear today is what I have been reading today is sort of it's a lot of puffery of Merrick Garland, just a lot of sort of, over the moon. We're very excited about this guy. So, a lot of the media sort of is reading like that today. So I want to skip all of it. Let's go right into his opening argument, his opening statement that he gave on the floor of the Senate Judiciary Committee today in the Senate. So it says here, Mr. Chairman, Mr. Ranking Member, and member of the Judiciary Committee, I'm honored to appear before you today as the nominee for Attorney General. I want to introduce you to my wife, daughters, son-in-law. They're all here and they're watching these proceedings on C-SPAN every day of my life. It goes on. The president nominates the Attorney General to be the lawyer, not for any individual, but for the people. July 2020 marked the 150th anniversary of the founding of the Department of Justice, and it's a fitting time to remember the mission. It is fitting time to reaffirm the role of the Attorney General, and that is to serve the rule of law and to ensure equal justice under the law. So as we're reading these, we just sort of want to point out some of these sort of legal phrases and see how they're using them. All of these, this guy's a lawyer, he's a judge, he's somebody who's been doing this for a long time. So his word choices are very distinct, right? They're carefully chosen. And it is a fitting time to recognize the more than 115,000 career employees of the department and its law enforcement agencies and their commitment to serve justice and protect the safety of our communities. So that's a lot of people, 115,000 people under his leadership. If I am confirmed, serving as the Attorney General will be the culmination of a career I have dedicated to ensuring that our laws of our country are fairly and faithfully enforced and that the rights of all Americans are protected. So basically standard boilerplate language that you see here, nothing particularly interesting. Before I became a judge 24 years ago, a significant portion of my professional life was spent at the Justice Department. Special assistant, the last of the post-Watergate attorneys. He was a line assistant U.S. attorney, supervisor in the criminal division, finally as a senior official in the Deputy Attorney General's office. And it goes on. Let's see here. Slides are moving slowly today. Many of the policies the Justice Department developed during those years are the foundation for reaffirming the norms that will ensure, so reaffirming the norms, okay, so it's sort of a return to order, saying that the last 4 years were not normal. Now we're going to reaffirm the norms that we're going to adhere to the rule of law. Policies that protect the independence of the department from partisan influence in law enforcement. Right, that's sort of a dig at Trump, I'm going to guess. That strictly regulate communications with the White House, that establish guidelines for FBI domestic operations and foreign intelligence collection. Ooh, see, so these are juicy words. What are the FBI domestic operation guidelines? So that's on his list. What are the foreign intelligence collection? What are those? Those are important issues that ensure respectful treatment of the press, unlike Trump, that read the Freedom of Information Act generously, which we can get behind, right? More information, more transparency, more accountability, that respect the professionalism of the DOJ's career employees and that set out principles of federal prosecution to guide the exercise of prosecutorial discretion. So some good stuff there, right? Some good relevant topics. Now we can't glean a position on some of these things. We know that he's talking about FBI domestic operations. I can guess kind of where that's going to go, but we're going to see. But I think the point here is that he's flagging that. He's putting a pin in that. He's sort of raising that up. We're going to be looking at this. We're going to be looking at that, right? We don't see much here about, let's say, immigration. Okay, that one's just kind of not there. We're talking about foreign intelligence collection. We're talking about Freedom of Information Act. He didn't say much about drug policies. He does talk a little bit about prosecutorial discretion. He's sort of laying out the framework that he's going to fill in a little bit. So let's see how this continues on. In conversations we had before this hearing, many of you have asked why I would agree to leave a lifetime appointment as a judge. I've told you I love being a judge. I've also told you that this is an important time for me to step forward because of my deep respect for the DOJ and its rule and its department in ensuring the rule of law. Celebrating the 150th anniversary, this was founded during Reconstruction in the aftermath of the Civil War to secure civil rights as promised by the 13th, 14th, and 15th Amendment. The first Attorney General appointed by Grant to head the department led it in a concerted battle to protect black voting rights from the violence of white supremacists, successfully prosecuting hundreds of cases against members of the Ku Klux Klan. Almost a century later, Civil Rights Act of 1957 created the Department's Civil Rights Division with the mission, quote, to uphold the civil and constitutional rights of all Americans, particularly some of the most vulnerable members of society. The mission remains urgent because we do not yet have equal justice. All right, so we're getting into some more policy prescriptions. So what are we going to do then, Judge Garland, if we do not have equal justice? What are we going to do now? Communities of color and minorities still face discrimination in housing, education, employment, and criminal justice system and bear the brunt of harm caused by the pandemic, pollution, and climate change. So we are talking a little bit about criminal justice reform now, right? We're talking about unequal justice, and he's specifically calling out the justice system as it relates to criminal law. 150 years after the department's founding, battling extremist attacks on our democratic institutions remains central to its mission. Battling extremist attacks. So we're seeing that language again, right? More and more of that. We've made point of that here on this channel. Domestic extremism, domestic violent extremism. We've already seen reference here, the FBI looking into domestic operations, talking about foreign surveillance and collection. Now we're talking about extremism again and equal justice. So a lot of the same language that you would hear from elsewhere in this administration, it's of course bubbling up. Now he's sort of applying for a job there, right? He's going through the confirmation hearing. So you would expect to see this type of language. And of course he is giving it to you. Now let's take a look at 1995 to 1997. He supervised the prosecution of perpetrators of the bombing of the Oklahoma City Federal Building who sought to spark a revolution. Does that sound familiar? Does that language sound familiar? That would topple the federal government. Sounds familiar, right? Sounds like maybe somebody who has experience in handling a 1995 to 1997 revolution that was trying to be sparked by the Oklahoma City bombing. Maybe they would be relevant right now because, according to many out there, there was something similar that took place on January 6th. So he's sort of hearkening back. He's saying, look, the biggest threat, Joe Biden, the biggest threat, Kamala Harris, the biggest threat to the majority senators who are in this chamber now are Democrats, and their biggest issue, largely that we've been hearing, or one of the biggest issues, I can't read their minds, but one of the biggest issues is white supremacists. It is insurrectionists. It is fear from this violent overthrow of MAGA Trumpists. And so he's going back now and saying, listen, I already dealt with people who wanted to spark a revolution in this country. I already dealt with people who wanted to topple the federal government before. I did that with the Oklahoma City bombings back in the 1990s. That's why I'm qualified for this position. It's just a job application, and he knows who he's speaking to. If confirmed, I will supervise the prosecution of white supremacists and others who stormed the Capitol on January 6th, a heinous attack that sought to disrupt the cornerstone of our democracy, the peaceful transfer of power to a newly elected government. So strong proclamation there that he's going to be prosecuting white supremacists and others who stormed the Capitol on January 6th. And I'm still looking forward to seeing what his sort of guidelines are on that, because there are currently a lot of, which I don't disagree with that, right? I think that I've said this consistently. Anybody who did storm the Capitol and breached it and caused damage should be prosecuted. If they're not prosecuted, then it's going to really wreck the entire justice system. I've made this point before. I've said if for some reason somehow there's a drop of 100 cases, everybody's going to be crying foul on this thing, and it's going to, I think, result in a worse judicial system than if we didn't formally prosecute the people who were involved at that date and time. And I know that might sound weird coming from a criminal defense attorney, but I just believe that to be the best way forward. If we did not prosecute them, then there's going to be, crying foul from every different angle, every different person in this country. Does that mean that they should go to prison for 20 years if they didn't really do much harm in the building? No, I don't think so at all. There are many people that we've covered on this show who showed up the day after or showed up that night and had no part in storming the building. Are they going to be prosecuted under this Department of Justice? Probably, right? And if it sounds like they're going to be prosecuting white supremacists and others who stormed the Capitol. So we'll see what that means, right? We just don't know what that means. If you were there, if you showed up the day after, we already know that they're currently prosecuting people who did not storm the Capitol. So what does that look like? Well, we're going to find out. This critical work is a part of the broad scope of the department's responsibilities. DOJ protects Americans from environmental degradation and abuse of market power, and from fraud and corruption, and from violent crime and cybercrime, and from drug trafficking and child exploitation. So then we get a little bit of some of the other things they do, right? So we have some immigration talk there, abuse of market power. Don't see anything about tech in there. We do see violent crime. We see cybercrime, right? What is he talking about? What is cybercrime now? Is it posting memes? Because this DOJ arrested somebody for posting memes in 2016. Now they were election interference types of claims, but they were memes on the internet. They were trolling. Is that a cybercrime or not? Well, it is under the current DOJ, but what is he going to do if he is confirmed? And it must do all of that without ever taking its eye off the risk of another devastating attack by foreign terrorists. The Attorney General takes an oath to support and defend the Constitution against all enemies, foreign and domestic. I am mindful of the tremendous responsibility that comes with this role. As Attorney General, later Supreme Court Justice Robert Jackson famously said, "The prosecutor has more control over life, liberty, and reputation than any other person in America. The prosecutor's discretion is tremendous. While prosecutors at their best are one of the most beneficent forces in our society, when they act from malice or other base motives, they are one of the worst." Yeah, and that's a pretty relevant quote, right? We see this a lot in our practice. Prosecutors can be very reasonable. They can be very accommodating. They can be very, I would say, inclined towards justice, and they can be the exact opposite of that. They can be very hard-headed. They can be very difficult to even have a conversation with, very stubborn, and they can really result in a lot of injustice. And so it's nice that he points that out. Jackson then went on to say, "The citizen's safety lies in the prosecutor who tempers zeal with human kindness and who seeks truth and not victims, who serves the law and not factional purposes, and who approaches the task with humility." That was the kind of prosecutor I tried to be during my prior service in the DOJ. That is the kind of spirit I tried to bring in my tenure as a federal judge. If confirmed, I promise to do my best to live up to that ideal as Attorney General. So kind of a little bit of a vanilla statement. I think that the only thing that you get out of there is a little bit of the white supremacy stuff. Of course, they're going to prosecute Capitol Hill, but this is a job application. The Democrats are in control of the Senate, so he is applying for the job, and he's telling them exactly what they want to hear. Of course, we're going to go after the white supremacists. We're going to go after the insurrectionists. We're going to, really sort of look at domestic FBI protocols. We're going to look at foreign collection of evidence. And then he just goes through and sort of checks the box, right? Silent crime, violent crime, drug trafficking, child exploitation, abuse of market power, environmental degradation, peaceful transfer of power, white supremacists, got it. Revolutions, got it, right? On and on and on and on. So not much to glean from that. Now, it was an opening statement. So today, we have 3 clips that we went through, so we can sort of dive in a little bit. Now, if you recall, we spent a lot of time on this with Amy Coney Barrett and some of the other judges when they were going through their confirmation proceedings. Not going to spend that much time. We've got about 3 clips here. The first one, I think, is very emotional, and this kind of gives a good insight into Merrick Garland, somebody who is emotional and actually has a lot of kind of depth to the person, right? And I wanted to play this one because I thought it was it was sort of heartfelt, right? I mean, I think he's genuine in a lot of what he says, and so let's just get this one up so you can see what I'm talking about here. It'll make more sense when I play it.
Senator, so I come from a family where my grandparents fled anti-Semitism and persecution. The country took us in and protected us. And I feel an obligation to the country to pay back. And this is the highest, best use of my own set of skills to pay back. And so I want very much to be the kind of attorney general that you're saying I could become. And I'll do my best to try to be that kind of attorney general.
I believe your heart, and I'm grateful that you are living that MICA mandate.
All right. So, when I hear that type of language from people in our government, and you see that kind of emotion and you see that type of expression coming out of them, I want to support that, right? We want more people like that in the government. I think more people should be a little bit more, understanding of some of the amazing things that this country has to offer. It sounds like he's recognizing that. Sounds like he sort of appreciates the things that make America good. And if he is going to go and try to do his best in that framework, we're going to give him the benefit of the doubt. At least I am. And we're going to see what he does. Now, if his policies come back out and they are in violation of the Constitution, or in my opinion, they are things that would make America not so great, right? The things that made America great when him and his family came over, if they're trying to water those things down or those underlying principles, yeah, we're going to hold him accountable to that. And I presume he's going to be confirmed, and we'll have 4 years of being able to hold him accountable and analyze his decisions and make sure they are in comportment with the Constitution. But today, we're not going to beat him up too badly, right? Let's just see what he has to say. Seems like a nice guy, has a lot of experience on the federal bench, in the federal courts, and so we're going to give him the benefit of the doubt. Now, not without a full pass, right? In this next clip, I think this is where he's having a conversation with Josh Hawley. Many people are still a little hot around the edges when it comes to Josh because of his role in something. I don't even know what it was, but because he objected to some of the electoral votes, which he's constitutionally allowed to do. People are still hot about that, but whatever. He's back on the Senate Judiciary Committee, and here he was asking questions from Judge Garland. And so one of the things that comes up, of course, as the chief law enforcement officer of the United States is, well, how are you going to enforce the law in certain contexts, right? We've seen the Capitol Hill riots. We've seen a lot of summer unrest. We've seen more and more protests that are still bubbling up and sort of smoldering around this country. And so Josh Hawley is asking him specifically, what's the difference between domestic terrorism? How do you define that? Because we've seen a lot of stuff. We've seen in Portland them throwing Molotov cocktails at a federal courthouse for months. Is that domestic terrorism? Here's Josh Hawley with Merrick Garland today.
Let me ask you about assaults on federal property in places other than Washington, D.C., Portland, for instance, Seattle. Do you regard assaults on federal courthouses or other federal property as acts of domestic extremism, domestic terrorism?
Well, Senator, my own definition, which is about the same as the statutory definition, is the use of violence or threats of violence in an attempt to disrupt democratic processes. So an attack on a courthouse while in operation, trying to prevent judges from actually deciding cases, that plainly is domestic extremism, domestic terrorism. An attack simply on government property at night or any other kind of circumstances is a clear crime and a serious one and should be punished. I don't know enough about the facts of the example you're talking about, but that's where I draw the line. One is both are criminal. but one is a core attack on our democratic institutions.
All right, so as you can see, that came over from Breitbart. They did a nice job clipping some of the good clips today, so go check them out if you don't already do though. They have quite good reporting over there. So a couple points on that, on what he just said. So it's this, you have to sort of tease out where he's drawing the line. What is domestic terrorism? So according to him, the line is drawn when there is an actual disruption of a governmental proceeding, right? That was his definition of it, which is kind of different than the way I've seen it. In Arizona, the way that it works here, we have a terrorism statute here, and it's if you're trying to influence a decision, right? So just think about that. So one is if you're trying to influence a decision, if you're trying to go out there and do something that is, terrorism related, and you're intending to do that in order to manipulate somebody's minds or to cause them to do something differently. So one example here that we just covered in Arizona is there was an officer who was at a town hall meeting, and we covered this story on the show, but this officer is sort of in a group with other people. They're talking about Mayor Gallego, who's a mayor here in the city of Phoenix, and she was talking about, sort of playing around with this defund the police movement. Right. And this officer was with other officers at a town hall discussing this issue. Well, what if the mayor moves some money around with the city council and they defund the police? Well, we have a police officer who's attending one of these things, and he says, if she does that, I'm going to shoot her in the head. Right? Terrible statement. We covered this. This was in the news. And another officer who was there said, you don't mean that. And he said, yeah, I do. I mean that. And so when we talked about this in the context of the show, of course, that officer didn't get charged. Maricopa County Attorney's Office here reviewed that and said, no, we didn't think it was a real threat or anything like that. But I know other people historically who have been charged with a terrorism charge for that. The reason being is because you're making a statement in order to influence somebody else's opinion, right? So that officer in this hypothetical is making a statement to influence an outcome, a political decision. I will do X unless they do Y. If she defunds the police, then I'm going to do this. In other words, she shouldn't defund the police and I won't do this, right? It's a statement to try to influence a political decision. And that's kind of a more, I would say, standard definition, at least in the context of where we practice in criminal law. I don't know what statute he was referring to on a federal level that says it's interference. That's sort of more in an alignment with, an insurrection. And so they were sort of talking about domestic terrorism, and they're trying to define when that is. So, you could make an argument on both sides. You could say, yep, it's only when they're in session. So if you go to a court building after 5 o'clock and you firebomb it, not terrorism, but if you do it while they're in session, that is terrorism. Seems kind of a weird way to distinguish just based on time, right? Because if you firebomb a court building and the building burns down, you just interfered with the next day of work pretty clearly. Right? Everybody's going to show up and their buildings burn down. Everybody's going to show up and there's protests outside. They can't get into the building because there's barricades and it's dangerous. So it's one of those distinctions that I just think if you try to, this is what judges do. This is what attorney generals do and prosecutors do. They compare and contrast. And they take two cars. They say, this one's red, this one's white. This one has a 4-cylinder, 6-cylinder. This one gets 25 miles per gallon. This one gets 50. And you sort of weigh them and you say, all right, this is the better vehicle for me to make my case. This is the better vehicle for me to operate. And you mix and match and you compare and you contrast them. And so what he's trying to do right here is to distinguish between prosecuting, this is my opinion of this, he's trying to distinguish why it's okay and justified to prosecute the Capitol Hill rioters, but not the summer unrest protesters, whatever you want to call them, Antifa, BLM, whatever. And what's the distinction? It's time. So he's trying to find a distinction between the two. In Capitol Hill, they were right in the middle of the day. They were in session. Therefore, that's domestic terrorism. But anybody in Portland, anybody who was part of the BLM protests that Kamala Harris bailed out when they burned down the 3rd precinct out of Minneapolis, that was after hours. So those people cannot be prosecuted as domestic terrorists. So now you know, right, from our incoming attorney general. If you want to avoid domestic terror charges, this is not legal advice, but according to his own standard, right, it doesn't qualify for that if it happens after hours. if it's not in session. And so when you're thinking about being an attorney general and talking about policy prescriptions for the entire country, you got to think about those things, right? Because now you could have a group of people, they just conduct their attacks after 5 p.m., whatever their local situation is. So, one of those answers that feels like he's trying to thread a needle, wants to prosecute the Capitol Hill people, but not anything that took place over the summer. We'll see how that works out. Here is another clip. We got Lindsey Graham now, who's asking him about the border. And the border, many people think, well, it's just immigration, customs enforcement. It's kind of a different division. It's not within his purview. But you got to remember, right? A lot of allegations of criminality are coming across the border. People saying it's human trafficking, drug smuggling, illicit trade, illicit goods, all sorts of problems at the border. Lindsey Graham is asking him if he's ever been to the border and if he knows anything about drug cartels exploiting the border. And his answer is, well, you can be the judge of it. Here it is.
Have you ever been to the border? Have you ever been to the U.S.-Mexican border?
No, sir, I haven't.
So I'd like you to go, because I just got back, because I learned that drug cartels are using our asylum laws against us. They will collect people to sort of rush the border, and once they're apprehended, they will claim asylum. And most of these claims, 90%, are rejected. And that will take resources away from securing the border and detecting drugs and protecting the nation against terrorism. This is a behavior by the cartels. Will you look into that practice of using asylum claims by drug cartels to weaken border security?
I had not known about this, and I will certainly look into this problem. I think the drug cartels are a major menace to our society, and the poison that they put into our streets is damaging communities of every kind. If they have a particular, if they have
I ask you to visit the border, I think you'll find patriots there, and when they make mistakes, they need to be held accountable. But that's one of the toughest jobs in the country.
All right, so kind of a bizarre line of questioning there from Lindsey. Well, kind of a yes, good, and no, bad from Judge Garland. I would say I think that first and foremost, I like the sort of the language that he is using in terms of being a law enforcement official. If he's talking about the drug cartels as being a problem, in my mind, what I can infer from that is maybe he's less inclined about prosecuting the drug users, right? Right now, what we see are a lot of people being prosecuted for low-level drug offenses, serious felonies, at least here in Arizona and many other parts of the country. And in my opinion, those people need help and treatment. They don't need incarceration. So currently, the way that our current justice system is set up, in my opinion, is it's very, very overly punitive for the users rather than the producers. And, law enforcement loves all day to go round up the users. They're very easy to round up. But the bigger problem is where a lot of this stuff is coming from. And, he's, as the chief law enforcement officer, talking about going after the cartels rather than the users, which would be a little bit of a different, change of course from Joe Biden specifically. Over the last 30 years, all of his crime bills, he has been very, very aggressive in prosecuting the average user. First offense, mandatory prison for crack cocaine during the 1980s. Of course, that really impacted African-American communities largely more than other communities. And they were just users, not necessarily people who were distributing the drug. So it's sort of a little bit of a change in course in terms of policy. So we'll see where that goes. On the downside, though, guy's never even been to the border, and he's not aware that the cartels apparently may be exploiting some of our immigration laws and some of the same policies that the Biden administration is going to be promulgating according to their new immigration plan and policies in order to facilitate more criminality into this country. So kind of just, oblivious to that. But he's an East Coast guy, Harvard guy, DC guy, been around Washington and the establishment for his entire life, sort of birthed and raised and bred within that vertical. And so, what can you expect from somebody like that? But he's answering questions, and we'll see what the Senate wants to do. Let's jump into a couple questions on this segment. We have here from Liberty or Death says, thank you, SCOTUS. Now we know the Constitution is just a suggestion. Courts and executives can write law if there is a pandemic. And Liberty, you're one segment ahead of us. That's going to be the next segment. We're going to talk about SCOTUS. We're going to go through the dissenting opinion from Judge Thomas. Underscore Shade said, saw one clip of Garland today, was not impressed. Threw Biden's name in there to hide behind. Seemed, no, he didn't sound or feel confident to me whatsoever. No feeling of a leader. And that's a good observation there, underscore Shades. I actually think that is pretty accurate, right? He doesn't have a big personality. He doesn't have sort of a Bill Barr, walk into the room with a lot of bravado. Bill Barr, during his last Senate Judiciary Committee, when Eric Swalwell was asking him questions, did you prosecute so-and-so? Did you subpoena this? And Bill Barr says, no. And Swalwell says, well, why didn't you? And he goes, well, why should I? Right? He was sort of a big personality, big bravado, sort of like a movie-ish lawyer, somebody who can go in there and just kind of manhandle the room or person handle the room, right? Whoa. But this is a situation where, Merrick Garland is sort of a small personality, kind of quiet, a little bit meek, kind of, kind of working for his words. We saw there in that exchange with Holly that he's, domestic and really thinking and digging for it. And, he's not going to be a trial lawyer. He's not going to be out there presumably in court, but he will be somebody who needs to be called in front of a lot of hearings and committees and things. So I can understand that critique. He's not particularly a strong advocate, vocally speaking. And well, we'll see where that goes. Good observation, though. We had Liberty or Death says, Garland said solitary confinement in prison is bad, but it is okay for governors to enforce lockdowns if it is deemed necessary for the safety of the people. I didn't see that clip, Liberty or Death, but that doesn't surprise me. I mean, largely what you get, I think, in these proceedings is somebody who is applying for a job, and so they're just going to tout whatever the generic administration party lines are, and he did a good job of that today. Wise One said, if a petition is signed, how many signatures do we need in order to get the election audited? So, Wise One, that's going to be entirely dependent on the specifics of what you're asking about. So, if you wanted to go to, I think, Wisconsin, they wanted like $7 million, and then they would just do it for you. In other words, you don't need signatures. You just need to pay the $7 million. Trump, I think his team paid like $3 million for a partial re-audit. So it just kind of depends on the state, the locality, what you want done. And they'll be able to give you more details on that. Want to Know says, did he answer any question or know anything at all? He just kept talking, but not saying much. Reminded me of Biden on court packing. Yeah, probably, right? That's probably true. I didn't watch the whole thing entirely. I just watched clips here and there. And you got to remember, right? These confirmation hearings are largely kind of just show pieces. They're looking for stuff unexpected, but you can make the same criticism about any candidate up there. I think you could make the same criticism about, Amy Coney Barrett or some of these people. They go up there, they answer the bare minimum because that's the right thing to do legally. Okay, when let's say we go to trial, we put our client on the stand. One of their instructions is do not answer more than you have to, right? Just keep it concise. Yes, no questions if you can, and minimize the amount of time that you talk. And that's, I think, exactly what's going on with Garland and most of these other nominees. So I know it's frustrating if you want answers to certain things, but you're not going to get them. Thank you for the question. Want to Know. Next one up is from Sharon Quidney. Any prison or criminal justice reform would be great. What I'm afraid of is that this regime is going to be coming after libertarians like me, anybody who supported Trump, maybe even white people in general. Yeah, I know, Sharon. So I think the libertarian comment is exactly right. I think the supported Trump comment is exactly right. And I can't really speak much on that last one, but they are talking a lot about sort of changing the conversation about it. And I don't know where that goes or what that means because I'm not an expert in that field, but I will tell you, that we're seeing new language, right? We're seeing domestic violence extremism. Well, what does that mean exactly? What does domestic violent extremism mean? What does racial equality versus racial equity mean? They're two different concepts with two different worldviews and two different paradigms and two different philosophical underpinnings. What does that mean? And that's what we're trying to glean here. We just have to have these continued conversations with these individuals to pin them down. And then once they do give you an answer, then we can hold them accountable to that standard. Liberty or Death says, how was the, quote, raid on the Capitol white supremacist when those that wanted the vote counted differently wanted Trump a white guy over Biden a white guy that put the constitutional amendment to ban desegregation? Maybe someone should tell the blacks and Hispanics and Asians that stormed the Capitol, that they are white supremacists too. The videos I saw, to quote the Democrats, look like America. Or am I missing something? So good question there, Liberty or Death. That's a provocative question for sure. I think one of the things that, so two comments on this, right? Something that happened, two things that I noticed, right? Number one is it was a real quick rush to judgment on the white supremacy stuff. A lot of that, right? Everybody who was there was a white supremacist. Okay. That was sort of the generalization. Then we saw two things interesting happen. Number one, before January 6th, Enrique Tarrio, who is not a white person, who is the leader of the Proud Boys, was arrested. Right. So the Proud Boys apparently was this white supremacist organization that was headed up by somebody who's not even white. So, right there, you're going, wait, what? Then right after Capitol Hill, many people were pointing out that it wasn't just white people there, right? There were other people who were there of different demographics. And so we saw an article come out shortly thereafter that said, how did they phrase it? It was something like stopping minority whiteness or something like that. I pinned the article. I think we talked about it on the show. There was an article. Maybe Miss Faith can find it. I can't remember where it was, but it's stopping minority whiteness. In other words, you are somebody who is identifies as a minority, but you still have some whiteness in you that is causing you to be a racist. And so there was an article from the New York Times. I can't find it right now. I'm going to find it at some point. But it's basically saying the people who stormed the Capitol Hill building that were not white were exhibiting minority whiteness or something like that. It was this convoluted way to say that even if they were not technically white, they were still white. Therefore, you can take this and connect this all back to white supremacy. It was a wild article. I have it saved somewhere. I have a screenshot of it somewhere. So, it's hard to make sense of it all the racial stuff and who's responsible for what, and everybody's trying to point their fingers at everybody else. It's tricky. We've got another one from Pinky2 says, my concern is staying with the Constitution. We are only hearing Dems say cancel whites and help minorities. Dems only want to say that. America needs someone that prosecutes anyone that did wrong, not according to political view, and helping minorities as long as they are not harming any other race. Well, yeah, Pinky, I agree I think that justice should be blind. And I know that is, in and of itself, people say that is a racist connotation, right? That justice is not blind, and that there's this established patriarchy of white male privilege and all of these different things, which are really hard to quantify, right? I still don't understand how it all works necessarily, or how they want to codify this, or how they want to pass a bunch of laws to deal with all this stuff, or what the solution is, other than to recognize it and have conversations around it. I don't know. But apparently they don't want many more conversations around it. So it's kind of hard to even talk about it, because if you do, you're going to get it. Somebody's going to get triggered and offended. And I just don't know. There it is. So Miss Faith pulled this up. Here it is. Just so you know, I'm not making this up. It's called multiracial whiteness. Think of this, folks. Opinion. To understand Trump's support, we must think in terms of multiracial whiteness. Okay. So here is Enrique Tarrio, who is not a white person, from what I can tell. It doesn't look like that to me. I think he's Cuban. Enrique Tarrio, that's him. Leader of the Proud Boys. And then we have this headline, to understand Trump's support, we must think in terms of multiracial whiteness. So even if you are multiracial, even if you're a different race, you also have whiteness in you, and that is responsible for your actions on the Capitol Hill protests, on the Capitol Hill riots. Therefore, you're still part of a white supremacy organization. You're just going, what the hell is happening, right? What world am I living in here? The Trump administration's anti-immigration, anti-civil rights stance has made it easy to classify the president's loyalists as a homogenous mob of white nationalists. But take a look at the FBI posters showing people wanted in the insurrection assault on the Capitol. Among many of the white faces are a few that are clearly Latino or African American. Such diversity highlights the fact that President Trump's share of the Latino vote actually rose in 2016, notwithstanding years of incendiary rhetoric. Yes, they're disproportionately white, but one of the more unsettling exit polls shows that up to a third of Latinos voted to re-elect Trump. So it's all, many black and brown voters, all of them stopped the steal movement. Then we think of Tario by contrast, rooted in America's ugly history of white supremacy, indigenous dispossession, and anti-blackness. Multiracial whiteness is an ideology invested in unequal distribution of wealth, power, privilege, land in the form of hierarchy and standing of one section of multiracial whiteness reflects an understanding of whiteness as a political color, not simply a racial identity. All right, so it's confusing, folks. I don't know how to make sense of this. I thought you had to be white to be a white supremacist. But apparently you don't. It's confusing. Somebody help me. All right, we got Liberty or Death says, response to Garland's Jackson quote, enthusiasm for a cause sometimes warps judgment. Former President and later Chief Justice William Howard Taft. Enthusiasm for a cause sometimes warps judgment. Thank you, Liberty. We got another one. We've got from Sharon says, I'm sorry, I don't buy that Garland clip as being sincere. Maybe I'm just cynical, but it seems to me that Dems are expert at playing on people's heartstrings, but are really guilty of overacting. AOC and the others. You're tough, Sharon. You're pretty tough. Who knows? Who knows? He seems way more genuine than AOC does. When AOC was over there in her white outfit, crying, hanging off the chain link fence outside that immigration center. Oh, come on. That was Instagram material. Okay, I'm a millennial. I can recognize Instagram material when I see it. Garland's, that wasn't Instagram material, right? That was just, some oldish guy on the floor of the Senate, just kind of, all right. I mean, speaking as a millennial, right? Oldish, right? It's not being pejorative. I happen to love old people. But my point here is, one seems genuine. The other one seems like it's AOC Instagram material. And Garland didn't hit that. But Sharon, you've got a discerning eye. So you might be right. We have Chris Wiseman. We got a Photoshop in the house, folks. We got a Photoshop, the big, beautiful spotlight of accountability and transparency. Thank you, Chris Wiseman. Chris Wiseman in the house delivering. It's kind of like the bat signal, R&R Law Group, into the sky. Beautiful spotlight of accountability and transparency. I love that, Chris. Thank you. That kind of made my day. That's fun. And, maybe one day we'll get one made up and I'll put a little mask on and I'll fall to my death off a tall building. We got Sharon Quidney says, looking at the Senate scene, do any of these people even know an ordinary person, a small business owner, a contractor, a builder, a laborer, a waitress, a truck driver? Very good question, Sharon. Probably not. Okay. I mean, if you are somebody like Merrick Garland, you went to Harvard college, Harvard Law School, you got a job at a massive law firm, you go into the Department of Justice, you become a judge. I mean, you sort of live in DC in that little bubble your whole life. He's never been to the border. He doesn't know, any of that stuff. And it's a whole different world, which is why I'm just such a big proponent of local. Think local. Because we know what's going on in our backyard. I'm born and raised in Arizona my whole life. I think I probably know significantly more about the border than Merrick Garland does. But he's in Washington, 2,500 miles away. He's going to pass rules that come and touch us here, even though he doesn't know anything about it by his own admission. Another one from Pinky Suit 2 says, okay, well, the OKC bombing would fall in line with what he's describing. He's prosecuted there. I'm from Oklahoma, so it was intense here. I'm hearing him say that even if a federal building is closed at night, it's still a crime. I could see his point if he does still go after both criminals, including the summer unrest rioters. Yeah, it's a good point, Pinky, right? So he didn't say that one was a crime and one was not a crime. He was just categorizing it. And I think I kind of glossed over that point, right? They are both crimes, but he's just categorizing them differently. And that's a big deal. Domestic violent extremism is a whole different can of worms than something like criminal trespass, which is a low-level misdemeanor, or destruction of property, right? Probably a misdemeanor, depending on the amount of destruction, might be a felony. But if you're talking about domestic violent terrorism, that's a whole different category. It's probably, life in prison under the federal statutes, depending on what statute he's talking about. So totally different game there, but we'll see where that ultimately leads. I think that his distinction was pretty bad, though. I mean, if it's just open or closed distinction, what does he do if they torch a building after hours? Does that count or not? All right. We got Chris Wiseman says Garland was a pretty good record on FOIAs and transparency as a judge, but mixed on Fourth Amendment cases. So this is Freedom of Information Act request, generally favorable to judicial deference to the state with respect to law enforcement and wartime executive power. Very troubling if you classify domestic extremists in 9/11 style commission and domestic patriot acts. Yeah, so some good insight and some good opinions there from Chris. So according to Chris, says good transparency as a judge. We all like that. Mixed on the Fourth Amendment cases. Fourth Amendment are typically your search and seizure cases. A lot of law in there in that realm, but search and seizure cases, typically liberals are sort of in alignment with my political philosophy on this. Sort of the joke is that conservatives on the court can never find an officer who did anything wrong. Right, every single cop. Well, they would have found it anyways. Inevitable discovery doctrine, or whatever it is. Right, many of them were objecting to Miranda rights and things like that. Whereas the liberals typically are better, in my opinion, on criminal justice stuff. They're more about sort of individual rights, more about search and seizure rules being adversarial toward the government. The government has to prove a lot, a higher burden than many of the conservative judges will care to admit. So, good little synopsis there from you, Chris. Appreciate that, Rob. From Jason Segal, how would you answer that question about the essential defining characteristic for domestic terrorism, the inside-outside business hours thing, or other criteria? So it's very good question. Basically, I think a better framework would be whether the action is intended to manipulate a policy, right? And so you have to just kind of think about this back. What is the root goal of terrorism? It's to cause terror in people, right? It's to scare the hell out of people so people don't do certain things. You can make the argument 9/11 was about, a penalty towards the United States for interfering in the Middle East, right? Very broad, simplistic argument, but they didn't like the U.S. being involved overseas. They committed an attack on this country in order to change the U.S. policy. So the U.S. stops interfering overseas, right? It's a very simplistic example. Actually, I don't think that's probably even 1% of really what happened there, but it's just an analogy, right? They took an action against somebody to influence the policy of that thing. And so, yeah, if you are a Capitol Hill rioter and you are intending to interfere with the government to change a policy or to change a prescription, yeah, I think that would qualify. But I also think that the the summer unrest people, same thing. If you're peacefully protesting, that's one thing. But if you're torching a Minneapolis 3rd Precinct building, if you're going to call the Capitol Hill rioters domestic terrorists, which I'm not sure that that's a fair definition, but if you are going to call them that, based on Judge Garland's own distinction, right? They were open during business, and if they're closed in the summer, I think that's a poor distinction. So I would say that the better way to just categorize them all would be to say anybody who wants to get out there and interfere with the functional operation of government is intending to do so to manipulate the political course that government entity is on. And anybody who is interfering with that is more closely aligned to this concept of terrorism, because it's a policy-based action versus not. So back to my hypothetical about the police officer, they were saying something and threatening something in order to achieve an outcome, a political outcome. So I think that's a better line in the sand versus somebody's open, something's closed. That doesn't make any sense. So we'll see, right? We'll see where that goes. Ma Fox says, I think people are vastly misconstruing the point Garland made with distinguishing horrendous criminal acts with acts of domestic terrorism. He's not saying that they did in Portland isn't criminal. He's specifically explaining it was deeply criminal, but not domestic terrorism by his definition. Yeah, I think that's exactly right, Ma. And if I skipped over that, I didn't mean to do that. He does say very explicitly, both are criminal. But my concern here is what is the difference between the two? Because if you classify something, so like let's take an example of gang crimes, right? In Arizona, at least, if you are let's say you commit a crime, it's one set of penalties. But if you commit a crime and it's part of a gang, it's a whole separate onslaught of penalties, significantly worse depending on what the underlying offense is. So just that designation opens up the door to a whole lot of other things. Same with domestic violence. Maybe that's a better example. Okay, if you get into a fist fight at a bar in the middle of the night with some random guy, that's going to be assault, maybe trespass, maybe disorderly conduct. If you get into a fight with your spouse at home, it might still be, even lesser, but because you're in a domestic relationship with that person, maybe nobody's even injured. But because there was disorderly conduct, it's now designated a domestic violence offense that automatically revokes your right to certain benefits. Can't return to the scene of the crime. In Arizona, there's questions over your ability to own a gun. It's a whole can of worms. So you have these modifiers. So here, if it's criminality in Portland, but it's criminality plus in Capitol Hill, why is that? Because one was open and one was closed? Are you serious? That's it? That's a pretty inconsequential distinction, in my opinion. Right? Somebody's going to get a domestic terrorism charge because they were there while the government was open. That's it. They're going to get another 10 years in prison because they were open and not closed. That doesn't make much sense. But we'll see where he goes with that. I think he was probably grasping for an answer and he didn't have a good one. But Merrick Garland, so we'll continue to follow that. I don't think that he's been confirmed today. He might get confirmed tonight. But if not, we'll have updates on Merrick Garland tomorrow. So stick around, subscribe. And if you missed that, we took those questions from Locals, locals.com/watchingthewatchers. If you want to ask questions on the next show, that's where to do it. All right, so enough with Merrick Garland. Let's change gears a little bit because we went long on that segment. We got a lot more to get to today. The Supreme Court also, over the weekend and today, released a whole new slew of orders that we have been following for some time. We've covered some of the election stuff. We've covered some of Trump's taxes stuff. We have a very good dissent on the Pennsylvania cases from Judge Thomas, Gorsuch, and I think there was another judge. It was either Alito. I think it was Alito who joined in with Gorsuch. So we're going to go through those, but I wanted to show you some of what the order looks like. So there was a lot of documents that came out today. One big document with a lot of stuff in it. This is what it looked like. So Monday, February 22nd, which of course is today, we have this order list that came out. Big document. And we clipped out a couple things that are pertinent. So number one, this is the Trump tax case. Donald Trump versus Cyrus Vance. The application for a stay that was presented to Justice Breyer and referred to the court is denied. So what are we talking about there? A stay. Okay. Currently, Donald Trump and the Trump organization is being investigated, and they want to get a copy of his financial statements, tax records, basically everything that's in that category of documents. And there was a request by Trump and his team to stop the order that was authorizing the accessing of those documents. So somebody else ordered that. They said, go get those things. Trump said, nope, hold on. We're applying for a stay to stop you from gathering those documents. And the Supreme Court just said, no stay. So you can continue to move forward and request those items. This was, according to the SCOTUS blog Twitter account, they said, breaking. After 4 months of inaction, SCOTUS, in a one-sentence, unsigned order, declined Trump's request to further postpone the enforcement of a Manhattan DA district attorney subpoena for his financial records. The order clears the way for the New York grand jury to obtain the records and review them in secret. So you see here, this is all we got on it. Not much. One sentence, little bit of a letter there. So, we didn't spend much time on this thing. We'll see where this goes. But not good news if you are Donald Trump, right? Now there's a Manhattan district attorney that has the ability to go in, request a subpoena, get one ordered by the court, get those formal documents pursuant to court order. The Supreme Court has said, nope, we're not getting involved. It's denied. Give them the records. So now they have to turn those over. We'll see what the DA wants to do with those. The next case that is something that we did spend a lot of time on is this, Donald Trump for president. Now, you may remember this used to say Bukvar. Remember Kathy Bukvar out of Pennsylvania? We spent a lot of time talking about her. She resigned, and so now we have this person who's in her place. It's D. Graffenreid, who's the acting Secretary of Pennsylvania, Secretary of State. And so if you don't remember this particular issue, a lot of election litigation that we covered, a lot of stuff was going on here. But out of Pennsylvania, this is one of the biggest complaints that I had in our I don't know, last 6 months of doing this show every day, that the Supreme Court did not get involved and answer this question before the election. I was critical of this before the election months ago. And now we're sort of getting to the culmination. Are they going to hear this case or hear this issue? Because it's been the same issue that's appeared in a number of different cases. But the underlying issue, getting ahead of myself here, is there was an election deadline in Pennsylvania that was on election night. The legislature settled that. It's done. Pennsylvania Supreme Court, long story short, moved the election day 3 days back. On their own. They didn't go through the legislature to do that. They sort of heard the case, said, you're right, we got to make all of these changes because of emergency situations, emergency orders as a result of COVID-19 spreading through the country. So the Supreme Court essentially just changed things a little bit on their own. And the constitutional question here was, can the Supreme Court do that? The Constitution grants the legislature the ability, the full ability, plenary power, the sole power to conduct elections in this country. And so if the legislature said that the election day is November 3rd and the Supreme Court comes back and says, no, it's November 6th, how is that allowed? How is the Supreme Court allowed to delegate, basically take away, shift election dates around when that's the sole power of the legislative branch? Can they do that? Well, the Supreme Court is basically saying, yeah, they can do whatever the hell they want. We don't care. Here's what the order says. The motion of the constitutional attorneys for leave to file a brief is granted, so they can go file a brief nobody cares about. The motion of the Republican Party to leave to file an amicus brief is also granted. That's fine. You can also go file a document that nobody cares about because the petition for a writ of certiorari is denied. Okay, we're not going to hear that case. And so if you recall, the way that this was sort of working its way up back during the election is there were a lot of questions about whether this was acceptable, whether a Supreme Court can move the dates on their own, or whether that's a separation of powers issue. Okay, you don't want every branch of the government just doing all of the jobs of the other branches of the government. We got to separate but co-equal branches of the government. Here, in my opinion, the Supreme Court of Pennsylvania was overstepping and sort of absconding with some of the powers of the legislature. That got litigated. It went up to the Supreme Court before the election took place on November 3rd. The justices, because Amy Coney Barrett was not on the court, split 4-4 as to whether to hear that case before the election. 4-4 means it goes back down. So the Supreme Court did not hear this case. If they would have heard this case, I think this would have solved almost most of the election questions that we had prior to the election, and even most of the post-election litigation, but they didn't do that. They said, nope, we're not going to hear it. So it went back down, and the lower Supreme Court ruling stood, which means that the 3-day window on Pennsylvania was allowed to stay. They pushed it back 3 days, no problem. So now the question was in front of the court, well, listen, we've got more elections coming up. 2022 is right around the corner. 2024 is right behind it. So can the state governments just sort of do whatever they want with the elections and the federal government's not going to get involved? Is that allowed or not? And the Supreme Court here today is basically saying it's allowed. Pennsylvania, their courts can do whatever they want. Georgia, they had a settlement agreement between Raffensperger and the Democratic Party. They can manipulate things. If you have an election commission, they can move dates around. They can change the rules on the margins. It's all allowed because every single case that has been challenging that has failed. And the Supreme Court today is confirming that. They are denying to hear this case. Now, let's go through the Supreme Court's ruling on this, right? This is from the majority of the court. So we can see here, Republican Party of Pennsylvania versus Veronica DeGavenfried. She's the acting secretary. She replaced Bukvar. Then we have a sort of a companion case also involving the Pennsylvania Democratic Party. So they consolidated these into one opinion. This was decided today, February 22nd. The motions of Donald Trump for president are dismissed as moot. Right? If you bring it too soon, it is not ripe. If you bring it and you're the wrong party, you have standing. If you bring it too late, it is moot. The motions are also dismissed as moot. The motions of the election projects are granted. They can file an amicus brief. An amicus brief is a friend of the court type of brief. They can also, the White House Watch Fund can also grant a brief, but the petitions for a writ of certiorari are denied. So that's all we get from the Supreme Court. Okay, that's it. Why are they not hearing this? We don't know. What we can do now is turn to the dissents. So what do the judges say about this? Now, it's actually sort of a long dissent. We're not going to go through the whole thing. We've got Judge Thomas that we're going to go through, and then we're going to go to Alito and Gorsuch. A couple points here that I think are worth pointing out. So Justice Thomas starts us off, and he says, the Constitution gives to each state legislature the authority to determine the manner of the federal elections, right? This is what I'm talking about. Article 1, Section 4, Clause 1. Article 2, Section 1, Clause 2. This is where they get the authority, the state legislatures get the authority from our Constitution to determine the manner of the federal elections. Yet, both before and after the 2020 election, non-legislative officials in various states took it upon themselves to set the rules instead. We covered a lot of it. As a result, we received an unusually high number of petitions and emergency applications contesting those changes. The petitions here present a clear example. The Pennsylvania legislature established an unambiguous deadline for receiving the mail-in ballots by 8 p.m. on Election Day. Dissatisfied, the Pennsylvania Supreme Court extended that deadline by 3 days. The court also ordered officials to count ballots received by the new deadline, even if there was no evidence, such as a postmark, that the ballots were mailed by Election Day. That decision to rewrite the rules seems to have affected too few ballots to change the outcome of any federal election, but that may not be the case in the future. These cases provide us with an ideal opportunity to address just what authority non-legislative officials have to set election rules and to do so well before the next election cycle. The refusal to do so is inexplicable. I could not agree more. Because the judicial system is not well suited to address these kinds of questions in the short time period available immediately after an election, we ought to use available cases outside that truncated context to address these admittedly important questions. Right? He's saying, we just saw what happened. We have like 2 months to litigate any of this stuff. That's not enough time. Now we have this case in front of us. We can decide on it so that the next time this comes down the pike, we are prepared. But the court declined to do that. Here he says, this is Judge Thomas speaking. This is Judge Thomas, a Supreme Court judge from the United States of America, saying this. Okay, it's not Linwood on Twitter. This is a Supreme Court judge, highly recognized, highly accomplished, saying this. Our refusal to do so, here we have the opportunity to do so almost 2 years before the next federal election cycle. Our refusal to do so by hearing these cases is befuddling. There is a clear split on an issue of such great importance that both sides previously asked us to grant certiorari. And there is no dispute that the claim is sufficiently meritorious to warrant review. By voting to grant emergency relief in October, 4 justices made clear that they think petitioners are likely to prevail. And that was the underlying case in October, right? We talked about this case. And I was very mad at Judge Roberts. Despite pressing for review in October, respondents now ask us not to grant certiorari because they think the cases are moot. That argument fails. So prior to this, both sides wanted to have an answer on it. Now, though, the Democrats are saying it's moot. So they don't want an answer anymore. They just want it dismissed because it's moot. It's irrelevant. Trump's not the president. Biden's the president. So what do we care? Well, the country cares because this is an important question. Can the Supreme Court just change things? Can an election commission just change things? We saw that happen around the country. Can they do that? Or does the legislature have that plenary authority? One wonders, according to Judge Thomas, one wonders what this court waits for. We failed to settle this dispute before the election and thus provide clear rules. Now we again fail to provide clear rules for future elections. The decision to leave election law hidden beneath a shroud of doubt is baffling. By doing nothing, we invite further confusion and erosion of voter confidence. Our fellow citizens deserve better and expect more of us. I respectfully dissent. It's a pretty good opinion there, Judge Thomas. Exactly right. And it is really unfortunate because if this does happen again, and it will, of course it's going to happen again, We'll see what they do. Now we have another opinion from Alito and Gorsuch, so the two other conservative judges. I agree with Judge Thomas that we should grant review in these cases. They present an important and recurring constitutional question. Specifically, whether the elections or the electors clauses of the United States Constitution, Article 1, Section 4, Clause 1, Article 2, Section 1, Clause 2, are violated when a state court holds that a state constitutional provision overrides a state statute governing the manner in which a federal election is to be conducted. That question has divided the lower courts, and our review at this time would be greatly beneficial. In the cases now before us, a statute enacted in Pennsylvania unequivocally requires 8 p.m. on Election Day. Nevertheless, the Pennsylvania Supreme Court used the state constitution that elections be, quote, free and equal, Article 1, Section 5. They altered that deadline and ordered that mailed ballots be counted if received up to 3 days after the election. This is a Supreme Court document, okay? YouTube. Both the state and Republican Democratic parties urged us to grant review and decide this question before the 2020 election. And we talked about that. But the court, an evenly divided vote refused to do so. We had Thomas, Alito, Gorsuch, and Kavanaugh. They all wanted to hear the case. Roberts joined the liberals, and they did not hear it. That unfortunate decision virtually ensured that this important question could not be decided before the election, and now we're dealing with it now. For these reasons, the cases now before us are not moot. There is a reasonable expectation that the parties will face the same question in the future and that the question will evade future pre-election review just as it did in these cases. These cases call out for review, and I respectfully dissent from the court's decision to deny certiorari. So that is where we're at, right? The Supreme Court is not hearing this issue. So what this means legally is that, yes, all of that stuff is fine. It's all good. Move things around, do whatever you want. Supreme Court can change things. Governor's office can change things. Legislature can certainly change things because we know they have the power. But now the Supreme Court has refused to weigh in on whether the Supreme Court has that power, whether election settlement agreements have that power, whether they can just modify whatever the legislature put in place. Not going to touch it. So the answer is yes, you can do whatever you want. All right. And guess what that means? We had 3 conservative judges who dissented. Where was Roberts? Where was Amy Coney Barrett? Well, we know where they are. All right. Couple other things on this segment. Of course, the Supreme Court rejected Trump's efforts to shield the tax laws. Okay, we already talked about that. Lastly, there was another election litigation case here called Wood versus Raffensperger. Remember that one? Certiorari also denied. So no Lynn Wood case out of Georgia either. Denied. So this basically wraps up all of the election litigation. Supreme Court denied everything across the board. And do you think anything's going to change between now and the next election? Probably not. Let's jump into some questions. We got E. Dantes says, if you can change the Constitution at will, then you do not have a binding law of the land. Even if there should a change made in election dates, if one branch can do it arbitrarily, then we don't have a constitution. Yeah, I think that's a good point, right? If you have a rule written down that you're supposed to follow and you don't follow that rule, then what the hell good is the rule? You just get rid of it, right? And that's kind of an instruction we have here at our office, right? If somebody passes a policy and then nobody's enforcing the policy and everybody's just doing whatever they want willy-nilly, then we just get rid of the policy. Because it's not being enforced. I don't want a bunch of stuff lying around that just is collecting dust. Maybe our Constitution should just go right into that bin of things that used to matter, because they certainly don't anymore. Pinky2 said, thing is, the Supreme Court of our land is only taking up cases for politics on their leaders' side. Our Supreme Court should take up constitutional cases. Our vote is freedom. Yeah, this is another interesting area where you can talk politics, right? Let's think about the Supreme Court in terms of just self-preservation. What if they did start issuing all of these orders that Joe Biden and the Democrats did not like? What if they said, yeah, we're going to hear Lynn Wood's case. Yeah, we're going to hear Trump's case. Yeah, we're going to deny your taxes. We're going to deny that whole investigation and just shut that down. Well, then what happens? You've got a lot of furor. You got a lot of fervor. You got a lot of outrage from the Democrats who then suddenly start clamoring to do what? Pack the court. So you sort of saw this back during the FDR era. Franklin Delano Roosevelt, when he was trying to pass a lot of his New Deal bills, the Supreme Court kept striking those down. Then he started to threaten to pack the court, I think, to bring it up to like 15. Something like that. Big number. Maybe bring it up to 13. I don't know what the number is. But he wanted to pack the court back then. And guess what happened? As soon as he made that threat, the Supreme Court changed their tune and they started approving a bunch of his bills. Right? So the court thinks about self-preservation just like any other political body in this country does. And here, it may have just been sort of an acquiescence to the Biden administration to say, yeah, look, we're not going to be too hard on you there, Joe. So don't think about packing the court. Who knows? That's just my cynical skepticism talking. Sharon Quidney says, this stuff coming down from the Supremes is outrageous. They are saying the Constitution is irrelevant. They are letting questions regarding the election go totally unanswered. Number 3, they are denying any possibility of justice. They just can't bring themselves to even appear to disenfranchise millions of unregistered, illegal, underage, dead voters. Truth be told, they probably just don't know what they would do if Trump proved his case. So it is... it is frustrating just from a legal perspective. I would just like to know what the answer is on that. I would just like a clear answer. I mean, they kind of gave it to us. They just said, yeah, they can do whatever they want. I don't know that that's what they intend. This may get settled later down the road because I think the repercussions from that are just not sustainable. It's not a good way to do things, right? How do you run a federal election if you got 50 states running different versions of elections? It's kind of a strange concept, but yeah, look, the Supreme Court, I say this a lot here, their claim to power is legitimacy. They've got to stay legitimate. And if they are not seen to be legitimate, then that is a huge problem for them and for the country. And so they're trying to do that right now. They respond to political pressures just like any other body does. They're supposed not to, but they certainly do. Chris Wiseman says, gotta love the logic. Before the election, no case in controversy. During the election, not ripe. After the election, it's moot. Estoppels, latches, and standing. Yeah, you can basically find any reason to do anything as long as it involves Trump and election litigation. Making sure that gets deleted. Thanks, Chris. We got Liberty or Death who says, this means that ACB, Kavanaugh, and Roberts voted the case down. Apparently, they are okay with non-legislators writing law. Fauci is the highest paid in the government. Makes more than Creepy Joe. Can he now write law too? Liberty, you're hot today. I appreciate that, man. Fire it up. Love it. All right. So, yeah, I mean, that's kind of what the courts are saying, to be fair, right? Anybody can just kind of, I think they're saying that it's up to the states, right? They're just deferring to the states. You guys do whatever you want down there. If you want to have your Supreme Court change the rules, have them change it. If you want to just sort of pull sort of obscure, irrelevant statutes out of your Constitution and apply that to federal election law, even though the state legislature has made clear what that looks like, and you just have this whole sort of internal debate, they're going to let it go however they want. Another one from Liberty. What is going to change is now that both parties will work very hard to out-fraud each other. Very good point. So that's kind of the intended consequence. I'm sorry, the unintended consequence of this. So I think the Supremes are saying this is kind of federalism. The federal government's going to step out of it. The state governments can go in there and conduct their elections however they want to conduct them. We're not getting involved. And so, yeah, now you just have parties on both sides just going haywire to just fight over the rules, change the rules to serve their ends. And that's, I don't know, that doesn't sound like a good solution to me, but I'm not on the Supreme Court. ACB is largely federalist from my understanding, probably against the 14th Amendment, so it doesn't surprise me too much. Yeah, I think so is Roberts, right? I think Kavanaugh is too. Yeah, so Roberts, Amy Coney Barrett, and Kavanaugh. Aren't they all Federalist Society judges? You can infer what you want from that. Good point there, Mom. So the Federalist group is sort of a libertarianish, pseudo-libertarianish group that a lot of people have a lot of criticism for. We got another one from Cats59 says, what is the process for recalling Supreme Court justices? Not for refusing to do their job and just listen to the cases. So the only remedy there, because they have lifetime appointments, Cats59, is impeachment. So you'd have to go through the formal impeachment process, just like we did in, what was it, a couple weeks ago with Donald Trump. Wise One says, Lin Wood flipped the script on the court system. He used the fraud as his defense against the state bar, trying to take his license. He informed every person on the board of directors of the fraud in Georgia. Now they have an ethical responsibility to investigate. Yeah, that I understand what you're saying there, Wise One. I just don't think that's the case at all. I mean, the board of directors, the state bar, they're not going to investigate any of these claims. I mean, basically, I think I haven't been following any of the Wood stuff because he's deplatformed everywhere. I think he's on Telegram now, but it's nothing that I don't think he's out maneuvering anybody. Right, he's talking like he is, but he's not. The state bar, the board of directors, they're not looking into any of this stuff. And even if they did, it's all moot. I mean, it is technically moot. Like, even if they found that this whole thing was fraudulent, there's nothing to do about that. You have to pass a constitutional amendment. You got to impeach Joe Biden. He's got to resign. You know, I mean, it's Lynn and some of these people just, continuing to promise like there's some secret trap door somewhere that's going to reverse all this stuff is not honest, in my opinion. I think they're being disingenuous, and that claim, I think, has long expired. Rebelling My Way says each state should operate how their residents wish. If the representatives are taking actions they do not agree with, they need to take action to remove them. It is the people's responsibility to stay informed and let their representatives know what they want. We, the people, need to take action. Our representatives will not. They are probably comfortable. I think that's a pretty astute observation there, Rebelling My Way. Yeah, I'm encouraging a lot of people to act locally because you have the biggest slice of democracy pie locally. The bigger you go, we're talking about senators and presidents and attorneys generals. Now you have a very sliver of that democracy pie. Here, you got a nice big chunk because you have less people competing with you for that pie. Want to Know says, what about the case Lin Wood filed against Roberts and Clinton? A lot of people don't think he is bluffing at all. I know a lot of people don't think that. A lot of people think that he's being sincere. I don't see any evidence of any of it. He's saying a lot of things that I think he's free to say, but I don't have to take any belief in any of it because I haven't seen any evidence about any of it. I've seen a lot of these claims, and we actually talked about one of Wood's lawsuits, I think last week, and he was actually it was an order to remove him as pro hoc vice from another defamation case that he was working on. So not even an election litigation case. He was just an attorney from out of state coming in and appearing on a case. It's called pro hoc vice. If you're not licensed in the state, you get sort of admitted into practice on a limited basis in a particular jurisdiction. Lin Wood is doing that, and somebody was trying to remove him from the case based on some of his prior allegations or some of these claims that he's making. And he doubled down in his court document and said, I still have proof. I still have evidence. And I'm saying, okay, where is it? If you got it, it's probably about time to show up because you're getting, now attacked by the state bar and all of these things. And listen, I am a proponent of free speech. I'm not saying that he should be thrown in jail or he should be disbarred even for any of this stuff. I think he's free to say it. I don't agree with any of it, but I think he's free to say he can have an opinion on a lot of this stuff. And listen, I'm not sort of avowing total freedom for all statements Lin Wood has ever made. I have not seen all of his statements, and I can't make an endorsement that is that big in scope. But the point here about him, challenging certain things and contesting the way that these things were working, at least in terms of the election litigation, he's got a right to pursue those claims and to make those claims and say those things. And the payback, the repercussion for that, I think is stepping over the line on free speech, and that is concerning to me. We got Farmer's Daughter says, I watched Alan Dershowitz today. He pointed out that this whole tax thing with Trump is finding the crime rather than looking into a suspicious crime. What are your thoughts on that? So I agree. I think that most of these things are political prosecutions, which is why I'm not particularly interested in them. You've got a lot of DAs around this country who want to make a name for themselves by prosecuting the next big person. I don't like when they do it with anybody, really. I don't think that the political system or the judicial system should be weaponized against people who are speaking their mind or who engaged in political things, right? Donald Trump is being investigated because of some tax stuff. Allegedly, they're trying to find a rationale in order to prosecute him, but I don't think that this comes from a general sort of acknowledgement or some secret tip that Trump and his team were doing something bad with their finances in the Trump organization. I think that this started off as a political witch hunt. They want to go find something that he did wrong. They're going to use the justice system in order to make a political point. We see the DA is now doing that also out of Georgia. And it's just something that's, everybody's trying to grift off of the outrage from the Capitol Hill riots. And if they find something, if they go through Trump's financial records and they find that he was embezzling whatever, then okay, right, maybe that was right. And we'll have to come back on here and eat crow. But I just, I think this happens on both sides. A lot of political prosecutions. I really do not like the concept of a weaponized Justice Department at all. And unfortunately, we just have a lot of that going on right now. Pinky number 2, last question before we move on to the next segment, is we're going to end up having more votes than we have voters for all the illegal interference on both sides. And the Supreme Court just said, okay, yeah, that's pretty much accurate. Supreme Court just said, yeah, states, run them however you want to run them. We're not getting involved. And if you're an attorney general from one of these different, I think 17 states who signed on, we're also not going to hear from you either. So I think the takeaway from this is that they are really carving out a massive expansion of the political question doctrine, if I can just go there. Okay, we've talked about here, who do you sue if you're mad about taxes? Nobody. That's a political question. The courts say you can't do that. You got to go and bring those claims in the political arena. Go vote. Go run for office. Go raise some money for your preferred candidate. But you can't sue the government. And the courts now are saying, don't sue us over the election stuff either. Don't bring it up. You guys run it however you want to run it. We're hands off. It's going to be a little bit of a free-for-all next time. We'll see how that works out. All right, let's change gears. Kind of going back into election stuff again. Remember, we can have no claims of fraud that change the election outcome. Can't say that here. All right, so let's change gears. This next story comes from a CBS local website. It's about MyPillow, the MyPillow CEO, Mike Lindell. He originally said that he wanted to be sued by Dominion, and so we wanted to just refresh on that one. He says, I want them to sue me. MyPillow Mike Lindell says lawsuit from Dominion would show the election is rigged. MyPillow CEO and Donald Trump supporter said he'd welcome a lawsuit from Dominion Voting, which is threatening to sue Lindell for slander. He interviewed with Sarah Cook on Monday. This was back in January. He said that the lawsuit would allow him to show that there were problems with the election. I want them to sue me, please, because I have all the evidence, 100%. I want all the American people in the world to see the horrific things that these machines are capable of and what they did to our country and what they're allowing other countries to steal our election and to just hijack our election. Dominion sent legal letters to Lindell in December and early January over his false and conspiratorial claims that the machines are being rigged or influencing the results of the election. And then his wish came true. New Dominion Voting Systems has filed a lawsuit against Mike Lindell and MyPillow seeking $1.303470000 in damages. That's $1.3 billion. So let's run through this. We've already covered this, I think, a couple times. It's a lot of the same stuff, right? Dominion was the software provider, the machine provider of the machines that counted ballots and were operating at the tabulation centers around many parts of this country. And now their lawsuit was filed today. Let's take a look at it. We see this was filed in the D.C. District, so Federal Court, District of Columbia, and it was filed today, February 22nd, 115 pages, so we are not going to cover it all. You can see it was Dominion Voting Systems, Voting Systems, Inc., Dominion Voting Systems Corp. Against MyPillow, Inc. and Mike Lindell, based out of Minnesota, as defendants to the case. Complaint and the demand for the jury trial. It starts. It says, after hitting the jackpot with Donald Trump's endorsement for MyPillow, and after a $1 million bet on Fox News ads had paid out handsome returns, Mike Lindell exploited another chance to boost sales, marketing MyPillow to people who would tune in and attend rallies to hear Lindell tell, quote, the big lie, that Dominion had stolen the 2020 election. As when MyPillow previously faced legal action for deceptive marketing companies, Lindell knew there was no real evidence supporting his claims. He is well aware of the independent audits and the paper trail recounts conclusively disproving the lie. But Lindell, a talented salesman and former professional card counter, like how they throw that in there, a professional card counter. All right. So he sells the lie to this day because the lie sells pillows. They're calling it a defamatory marketing campaign, which is a new concept, with promo codes like, quote, Fight for Trump, 45, Proof, and QAnon. They say it has increased MyPillow sales by 30 to 40% and continues duping people into redirecting their election lie outrage into MyPillow purchases. So that's an introductory little paragraph there. And you know, I don't know much about Mike Lindell. I don't own any MyPillows. I hear they're lovely, but I just don't own any of them. And don't know much about the promo codes or any of that stuff, but it is interesting how they're framing him as a former card counter. You know, I mean, they're trying to just kind of twist that in there as much as they can. Moving on, it says bipartisan election officials, 59 security experts, Raffensperger, Secretary of State, all these people say that these are false claims. They've rebutted them. Paper ballots are hard evidence, so they're going to go through all this stuff. The contrary evidence put forward by Lindell's allies, including Powell, Wood, and others, was they're calling it deliberately misrepresented, manufactured, cherry-picked, and sourced from con artists and conspiracy theorists who were judicially determined to be wholly unreliable. And they're saying Lindell knows all this. So what they're trying to do here is, you got to remember, when you're sort of a public figure in a public company, you got to have actual malice. So what they're claiming here is that Mike Lindell knew that these claims were not accurate. He knew that they were fraudulent, and he was making them specifically because not because he believed in America, not because he believed in democratically run free and fair elections where every real vote is counted. None of that stuff. They're saying, none of that matters. Okay, this guy's a charlatan. He's somebody who has been counting cards in the past. He capitalized on Fox News. He capitalized on Donald Trump. Now he's capitalizing on this fervor and outrage about the 2020 election. And he knows that what he's saying is wrong, and he's saying it anyways. That's actual malice, right? He's making a statement maliciously against somebody. And when you're a public figure, that's kind of what you need to have. It's more than just he's expressing an opinion, right? I think Dominion cheated. All right, well, you can make that claim. He's saying, I know that they're saying he knows that's not true, and he's doing it anyways. It's malicious. And he's doing it to sell pillows, is what they're claiming. Instead of retracting his lies, he is a multimillionaire with nearly unlimited ability to broadcast his messages on conservative media, saying he's censored and attacked. He produced a docu-movie featuring shady characters. Through discovery, Dominion will prove there is no real evidence supporting the lie. Dominion brings this action to vindicate its company's rights, to recover damages, and to seek a narrowly tailored injunction to stand up for itself and its employees, and to stop Lindell from further profiting at Dominion's expense. And so let's get on over to the factual allegations. Through aggressive marketing, he builds a multi-million-dollar company, and he does do a lot of marketing. Let's see. He's got some MyPillow baggage. He settled some claim for almost $1 million, settled another claim for almost $100,000, disseminating false and misleading advertisements. So they're saying he's got a history of some of this stuff. Class action lawsuit saying that he's a sleep expert. No, he's not a sleep expert, right? So they're sort of going through here saying that the MyPillow is not any good. So they don't like MyPillow. They think it's a bad pillow. Despite MyPillow's history of run-ins with the law, it became successful. $300 million in revenue. Wow, that's a lot of pillows. MyPillow's success is due to a gamble Lindell made on Fox News. He went all in, $2 million in airtime. It profited. He got $8.8 million back. That's a good return. 15% of revenue for Sean Hannity shows. That's a pretty good pillow. That's a good return. Maybe we should advertise on Fox News. It's pretty good. We got here it is. So they've got some clips. Donald Trump endorses MyPillow during a nationally televised White House meeting. Okay, so Lindell also touts the endorsement during an interview on Fox News. So, all right, so he's got Trump on his side. He's got 2 thumbs up right there. Looks very happy. He goes over onto Fox. He's also there. He says Lindell understood what really happened on election night. So he knew everything about it. Lindell knew Trump had discouraged his supporters from voting by mail, as evidenced by the fact that Lindell himself retweeted 2 of his Trumps. So they're using tweets now. So a retweet is now actual knowledge of something. All right. We got here, paragraph 30. Election officials in many states were prohibited from counting mail-in ballots before Election Day, but then he goes out there and makes a claim otherwise. And this just goes on and on and on. We're not going to spend a lot of time on it. We've got here the Women for the American First March for Trump bus featured MyPillow's logo on the front of the bus. So they're really connecting him to Donald Trump. Big time. Count one, defamation per se. So they're saying that he intentionally made malicious statements. He knew or recklessly knew that those statements were false. So see this sentence here? This is basically the money sentence. By December 12th, at the very latest, Lindell knew or recklessly disregarded that his statements about Dominion rigging the election and using algorithms to manipulate the vote were false. So he knew and he disregarded it. And that's basically the crux of this complaint. Count two, deceptive trade practices. All right, so they're going back to Minnesota law, and they're going to say that, defamatory falsehoods about Dominion were deceptive, so that this is sort of a state law argument. Let's see what else we've got. Prayer for relief. So this is where it's at. We've got $651 million in compensatory damages. So they're saying they lost $651 million, and they need to be compensated for that. Another $651 million in punitive damages. So a 1-to-1 ratio here. They want all expenses and costs of litigation. They want an injunction requiring the removal of all of defendants' statements that are determined to be false and defamatory, and stopping the defendants from repeating such statements or engaging in any further deceptive trade practices relating to Dominion. Signed off on by Thomas A. Clare. Thomas A. Clare? Sounds delicious. All right, so we have another lawsuit there. Where's that going to go? I am still waiting for a response. I know Sidney Powell got one of these lawsuits. I know Lou Dobbs and those guys got these lawsuits over at Fox News. Maybe that's why Lou Dobbs isn't there anymore. I'd be curious to see what the responses look like to all of this. We got Sharon Quidney starting us off. Says, well, with the Lindell lawsuit, maybe the truth will come out finally without the dubious, quote, help of the Supremes. Yeah, I wouldn't hold your breath on that there, Sharon. If Dominion sues Mike Lindell and loses the case, will Dominion be forced to pay all legal fees? It depends. The judge, this gets decided at the end, so the judge sort of decides on it. If the judge considers one side to be promoting frivolous claims, they may penalize that side for the cost of the frivolous claims or the cost of the litigation, at least within the scope of those claims. So we'll see. It's too early to tell on that one. Croc1 Alpha says former card counter, or as we former casino croupiers call them, people who are paying attention. Is that a word? Croupier? Is that how do you croupier? Like a craps? Is that like a craps person who throws the dice? Crappiers? Croupiers? I don't know. You can see how much gambling I do and how much time I spend in Vegas. Not much. Wise One says, I bought some Mike Lindell pillows, paid cash for them, and did not wear a mask when I did it. I sleep well at night. The pillows are a great investment. That's good. That's good, Wise One. I don't have any. Maybe I'll have to pick some up if they're that good. Jeremy Matrita says, it will be difficult to prove what someone does or does not know. Yeah. And that's where a lot of these, I think, sort of get into the rub, right? If somebody genuinely believes that, and I think that there's enough, I hesitate to use the word evidence, but there's enough out there that I think that you can make an argument, right? And it may not be an argument that holds any water in a court of law, but you can at least, there's conspiracy theories about everything, and some of them sound pretty good. So, it's going to be hard to prove what Mike Lindell really believes. I think the next jump there will be, was he repeating stuff that was so removed from what they're going to try to show he knew? In other words, he can believe something, but it's not a rightful belief. And their argument is going to be that he was making claims about things that he should have known were false, and he was doing it at such a high volume and so repetitively that he should have known, or would have been foreseeable, that this would cause long and substantial damage to Dominion as a company, and therefore he's liable for those damages. And I think it's a very stretched out argument. You got to connect a lot of things. And as I've said about this particular lawsuit, a set of lawsuits from Dominion, they have to know that they're not collecting $1.5 billion or $1.3 billion from Sidney Powell, Lou Dobbs, and Mike Lindell. right? But it's not about that, right? This is a sort of in the court of public opinion. They're suing everybody for $1 billion to regain some of their company's legitimacy, to say we're going to fight these things, to say that if this comes up again, you're also going to be subject to $1.3 billion in liabilities if we are successful with our lawsuit against you. It's sort of to chill the objections, I think, the next go round. And so it's more of a political, policy-based victory that they're looking for rather than an actual litigation victory. Now, I think that they would be very happy if that last part of what they were claiming, what they wanted, their prayer for relief, if they really do get Mike Lindell to stop talking about this, pull all of his documentaries down, pull all of his posts down, then I do think that that would be a win for Dominion. So that may be what they are looking for. We got Ma Fox says, gross negligence is a form of malice. The objective reasonableness standard is used, if I recall. So yes. So I think that's accurate, Ma. I don't spend a lot of time doing a lot of defamation work in general, but I think that is probably right. If you could make that connection that he didn't, he may have believed what he was saying, but he was saying it at a volume and at a repetition so sort of pronounced, and he had enough information, or should have had enough information, or we can show he had enough information through retweets or interview appearances or whatever, that people had presented him with enough evidence that it wasn't true, and he said it was true anyways, and so they could make that argument that that was grossly negligent. You were looking at this set of facts in front of you, and you just disregarded them all. You made a conscious decision to disregard it. It's like jumping out of a plane. Hey, your parachute's not ready. Yeah, I think it is ready. I'm telling you it's not. Yeah, but it is. Well, don't jump out of the plane because it's not going to open if you jump. All right, well, I'm out of here. I'm jumping. Right? That would be grossly negligent. You can believe whatever you want. You can believe that the parachute's in there, but when you jump out and it doesn't open, you pay the penalty for that. So it's not a perfect analogy, but it's saying you're entitled to believe whatever you want, but you're not entitled to go out there and say anything that's going to damage other people. If you do so in a way that was so grossly negligent, you can be sued for that. So I think that is what Dominion is claiming, but I'm not sure that these lawsuits are going to go anywhere. Jeremy Matrita says, should he have qualified his allegations with, quote, allegedly? So I think that is just a sneaky little trick that people think works, right? So if you go out there and you say, well, allegedly somebody's a child molester, and allegedly he's a child molester. I mean, it hasn't been proven in a court of law, but allegedly that person is a child molester, and you're just broadcasting that every day, all over the place. I think at some point they're going to sue you, and the courts are going to say, yeah, you don't, it's not like a get out of jail free card just because you put allegedly in front of it, or in my opinion in front of it. I have a habit of doing that, just to be clear, but it's not something that I think a court's going to go, hey, Dominion, he said allegedly. So got to let that go. Sorry, guys. Mike Lindell is open. He's a former drug addict even, says Pinky 2. He has a great story of turning his life around. Dominion did not really cheat, but their system may have allotted others to tap in. For lack of how to put this, got to be careful with some of that. Mike has proof. He's on video, so you can watch that if you want. In my opinion, Dominion machines are a tool. Yeah, so yeah, good stuff there, Pinky. Obviously, we got to be careful with, some of the claims being made out there because of some of the YouTube rules. I apologize for it, but I know you understand why we got to be careful with it. It's just how it is now. We have Remark 2 says, how did Dominion lose all that money? Didn't they already get paid to run the elections? Yeah, I would be curious to know a little bit more about that. What were their damages, right? They got to prove damages. They're seeking $1.3 billion from several different people. Where do they get those numbers from? What's justified there? Did they lose contracts with some of these other cities or not? We got Chris Wiseman says, so if truth is a defense to defamation and they are claiming lost economic gains, interference with contractual relationships, for example, they lost actual or prospective business, I'd imagine that those contracts and the related machine manual specifications and forensic examinations would be relevant and subject to discovery. So you're just Chris, you're allowing me to just jump right off of Remark 2's question, which is exactly on point, right? What are the damages and how did they come up with a concrete number for that? Did they lose contracts? Did they have to pull out of certain things? Did they cancel business relationships? Where did that 1.3 billion? Well, I know where half of that came from. It's from punitive damages, but at least the other half of it, $600 something million. What did they lose specifically? Is it Is it a quantifiable number? Where do they get that? And what Chris is saying, well, if they have to prove damages, then then naturally you would have to go and investigate that. And the other side is not just going to cut them a check for $670 million. Oh yeah, that's it. Okay, here you go. Here's $670 million. You comb through that and you're able to detail what goes into that number. So Chris, I think you're on the right track there. All right. So a couple quick stories I wanted to just cover here. Running long today, but enjoying it. A lot of stuff out here. In Arizona, we have a news story from KJZZ, which is a friend of mine. Actually, I don't know if he would call himself a friend. I'm a friend to him because I love his work. I love what he does. Jimmy Jenkins, I've brought him up a few times. This is his organization, kjzz.org, and there's a new article here posted today, sort of an exclusive to their organization. It says whistleblowers came out in the state of Arizona. And they're saying there's a software bug that is keeping hundreds of inmates in Arizona prisons beyond their release date. So in other words, people are scheduled, they're due to get out of custody, but because we can't run software in this state, they're not being let out. What? And a whistleblower from the prisons is now coming forward and saying they're supposed to be out, they're not getting let out. Here's what's going on. We have, according to the Arizona Department of Corrections, whistleblowers. So Arizona DOC, that's our Department of Corrections. We got whistleblowers here. Hundreds of incarcerated people who should be eligible for release are being held in prison because their inmate management software cannot interpret current sentencing laws. First of all, this is not funny for those people. This is not funny at all. I'm laughing at the joke of a bureaucratic mess that we have here. The inmate management software cannot interpret the current sentencing laws. Okay. That's kind of the entire job, right? To manage the inmates. One of the most important things to do with inmates is to release them. Probably the most important thing. So that you're not keeping them past their sentence dates. Pretty much the most important thing that you can do in there, aside from keeping them alive. Letting them back out when they've paid their dues. And we have management software in our Department of Corrections that apparently can't tell you when to let them out. Do they have a calendar there? Because that might help them. We have KJZZ is not naming the whistleblowers because they fear retaliation. The employees said they have been raising the issue internally for more than a year, but prison administrators have not acted to fix the software bug. So not only is it in total incompetence, but they've also just total negligence, right? They just haven't even attempted to fix it. No acting there. Sources said that Chief Information Officer Holly Green and Deputy Director Joe Profiri have been aware of the problem since 2019. AZ Department of Corrections confirmed there is a problem with the software. So when these types of things come up, I just like to bring them to everybody's attention so that we know what's going on. Right? You like to think that your government just functions properly, but little stuff like this is going on and you'll never know about it unless you have a whistleblower, unless you have somebody come out and say something about it. Now we have it. We see here as of 2019, the department has spent more than $24 million in contracting with an IT company called Business and Decision North America to build and maintain the software program. $24 million is known as ACCIS, ACIS, that is used to manage the inmate population in state prisons. One of the software modules within the software is designed to calculate the release dates for inmates. It's presently unable to account for an amendment to state law that was passed in 2019. Senate Bill 1310, authored by a former senator, Eddie Farnsworth, amended the Arizona revised statute so that certain inmates convicted of nonviolent offenses could earn additional release credits upon the completion of programming in state prisons. Doug Ducey signed the bill into law June 2019, but department sources say the software is still not able to identify the inmates who qualify for SB 1310 programming, nor can it calculate their new release dates upon completion of the programming. We knew from day one this wasn't going to work, a department source said. When they approved that bill, we looked at it and said, oh shit. Right there. Oh shit. After repeated internal warnings, employees sent a report to department leadership in October 2020, specifically detailing the software bug. And this is what that actual issue looks like. So we got a high-level enhancement functional analysis. We have a change request using 1 to 2 sentences. description. This is a new calculation altogether. Instead of this comes from the Earned Release Credit Drug Offense Release. High-level enhancement functional analysis, original document 1022. We have an example. We got, okay, so meaning the inmate would only have to serve 70% of the sentence. So they're trying to do some calculations here. However, only the currently developed release dates shall show as the final dates, and a new 3, 4, 7-day calculation dates still show as pending until the inmate meets all the criteria. So this is sort of their we got a problem here form that they're submitting. So they're trying to figure it out. I've been trying to do it apparently since 2020, if not 2019. Currently, this calculation is not in the software at all. It can calculate 1 earned credit for every 6 days served, but this is a new calculation. Instead of fixing the bug, the department sources said employees are attempting to identify qualifying inmates manually. Arizona Department of Corrections spokesperson Bill Lamouret said the department has been able to identify 733 inmates that are potentially eligible to take part for the early release programming. They're not enrolled in the program. They're prioritizing those eligible for this type of release. They're going to put them in a program space as soon as openings become available based on a release timeline. But the sources say the department isn't even scratching the surface of the entire number of eligible inmates. Folks, you have a law that is allowing people to earn extra credit to get out of custody, and the people who are in charge of keeping them in custody are not deploying a program that gives them the option to pursue this course. The only prisoners that are getting into the programming are these squeaky wheels, the ones who already know they qualify, or people who have family members outside advocating for them. That's right, people with attorneys, people with a lot of family, people with some other connections to the world. Not the people whose families abandoned them, or who can't afford an attorney, or have addiction problems or mental health problems. They just get thrown in there. They're relying on the government to maintain their lives, including telling them about these options that have been lawfully passed into law. And 733 people were identified manually. And according to these whistleblowers, not even scratched the surface. So there are people literally sitting in custody who could probably be working their way out right now, who definitively could be working their way out right now. Even if inmates are identified and they're able to complete the required programming, department sources say the software is preventing the prisoners from getting the time they deserve taken off their sentences. So they can do the work, and the computer program will not let them out. These people are literally trapped. We can't get them out the door, even if they complete the programs. We have a couple modules they spent millions of dollars on that we can't use at all. Millions of dollars. So, when you hear, law enforcement, prisons, law enforcement, prisons, we got to give them more money, more resources. $24 million for this software. Couple $1 million. Can't even use it. Can't even use it. The program that tracks inmates is not working properly. They went back to the old-fashioned way of tracking it with hand and paper because the software can't do what it's supposed to do. It replaced an older program called AIMS. DOC has spent more than $24 million replacing the system. It said that the requirements for the projects were poorly scoped from the beginning, resulting in a contract that went millions of dollars over budget. You don't say. Sources claim poor leadership. They blame IT. I'm sorry, they shouldn't blame IT. IT always gets blamed, but it's usually leadership. Poor leadership. These are the choices. They're being made like business decisions when they need to be thinking about what's in the best interest of the staff and ultimately what's in the best interest of the inmates. Another source said that they were disgusted with the way that the department has dealt with the software problems. I'm embarrassed to be associated with people that don't care enough to make these things a priority. It's absolutely inhumane to keep people in prison longer than they are supposed to be. It's inhumane. It's illegal. It's unconstitutional. It should open up a whole door of additional lawsuits that should be compensated a lot more than $24 million. It's infuriating, but this is everywhere. This is everywhere. All right, our next little quick short story. This one's funny. It's funny because it's ridiculous and it's not going to pass, I don't think. Well, we'll see. I don't live in Oklahoma. Maybe this will fly through in Oklahoma. All right, next story. Over from the AP, we have new legislation coming out of Oklahoma that is going to protect drivers who hit protesters. That's their headline. So the situation here, as we all saw over the summer, we had a lot of summer unrest, a lot of people sort of out in the streets, blocking the roadways, joining hands, creating these human chains, stopping, major intersections, major freeways even. And, what do you do about that? If you're on your way to work, you got to get there. Well, you got to stop. You can't just run through a crowd of people. Until today. Now we have a new bill that's being introduced out of Oklahoma. Let's go through it. It says, out of Oklahoma City, when massive demonstrations against racial injustice erupted across the nation last summer, protesters used an increasingly common tactic to draw their attention to the cause, swarming out onto major roadways to temporarily paralyze traffic. This method sometimes resulted in searing images of drivers plowing through the crowds, causing serious injuries and in some cases deaths. Now, Republican politicians across the country are moving to stop the roadblocking maneuver, proposing increased penalties for demonstrators who run into highways and legal immunity for drivers who hit them. So penalties for demonstrators is number one. Number two, legal immunity for drivers who hit them. That's number two. So hopefully the standard is a little bit higher than that, right? In the actual law. For protesters in the street, do you have to be fearful of them? Do they have to be on your car? Do they have to be attacking your car? Or can you just, like in a bowling alley, just right on through? With legal immunity, let's find out. The bills are among dozens introduced in the legislatures aimed at cracking down on demonstrations. It's not going to be a peaceful protest if you're impeding the freedom of others, said Rep. Kevin McDougal, the author of an Oklahoma bill granting criminal and civil immunity to people who drive into crowds on roads. Quote, the driver of that truck had his family in there, and they were scared to death. He referred to an incident in July in which a pickup truck pulling a horse trailer drove through a BLM protest on Interstate 244 in Tulsa. 3 people were seriously injured, including a 33-year-old man who fell from an overpass and was left paralyzed from the waist down. Well, that's not good. Tumultuous demonstrations by left-leaning and right-leaning groups have stirred new debate about what tactics are acceptable free speech and which go too far. In addition to blocking roads, Black Lives Matter demonstrators have taken over parks and painted slogans on streets and structures, while right-wing groups have brandished firearms and stormed Capitol buildings. Local authorities' responses have wavered as they try to avoid escalating conflicts. Now, legislatures in Iowa, Missouri, Oklahoma, Utah, and a dozen other states have introduced new counter-protest measures. So be aware of what those look like. The traffic blocking tactic has attracted the most concern because of the obvious hazard. And it looks like this is clearing the House. The immunity bill, granting drivers immunity for hitting protesters, easily cleared the Senate, 8-1 vote. 2 others are pending in the House. They're saying that these proposals are only designed to intimidate people, not to solve a problem. The biggest concern is that they chill speech and they chill folks gathering to protest, said somebody from the ACLU. About 50 people were arrested during the several days of protest. Most of those were for things like disorderly conduct, misdemeanor, a felony for rioting that carries 10 years in prison. 2 men were accused of burning a sheriff's van. They're being charged under the anti-terrorism law. Yeah, but wait, anti-terrorism though. Was the van open for business or was it after hours and closed? If it was open for business, that's terrorism. If it's closed, not terrorism. According to Merrick Garland, we have a felony that says that that's a felony, burning a van. Those cases are pending. Proposals in Oklahoma would increase the criminal penalties for blocking a roadway, making it a felony. Another bill would add participating in unlawful assemblies to the state's racketeering act at organized crime. So what do you do about that stuff? Do you allow people to just run over people? So we don't have the specifics of the bill here, but I'm going to guess that if you're reasonably fearful for yourself or your safety, then that would be okay, not just a free-for-all pinball machine out there on the streets. Interesting bill. I wasn't aware that this was something that was sort of percolating around the country. It says that a lot of states are considering some of this stuff. So I just wanted to give you a little bit of a heads up on that. All right, so we've got some questions here to wrap up the program. We've got one from Sharon Quidney. He says, whoa, folks are being held overtime because of software problems. Oh man, they need to file a lawsuit. And they will, Sharon. Believe me, there will be many of those coming down the pike. Farmer's Daughter says, Robert, you have a great laugh. I don't know about that. I feel like I giggle like a schoolgirl here. We got Wise One says, who is the software company? SolarWinds? Yeah, that's a good one. So solar winds, we talked a little bit about, and Sharon has said no, Dominion. So Sharon, I think he was being facetious over here. Solar winds was that massive company who got hacked. And apparently that story is just gone with the solar wind. Nobody's even talking about it anymore. Apparently, we talked about it for like a week here, and then I wanted to continue to cover the story, but it was all just sort of gone. This is what they were talking about, hacking the nuclear silos and things like that. I mean, getting access to the codes and all that stuff, and it's just gone. Not that big of a deal, I guess. We got Just XUXA says, look for a gift heading to your office. Sweet dreams via AMZ. All right, well, I'll be looking forward to that. Did you send a MyPillow? Oh my goodness, that's hysterical. If you did, that's hysterical. I'll lay my head down and think of you and Mike Lindell in my sweet slumber. That's too funny. All right, well, thank you for that, Just XUXA. We'll be on the lookout for that. All right, we've got another one from Liberty or Death. Says, Robert, criminal law question. In Garland's hearing today, they were talking about reauthorizing the Violence Against Women's Act, which I feel is unconstitutional and does nothing. Violence against people are already illegal, and the act violates Equal Protection Clause. Under VAWA, a misdemeanor conviction for DV strips your Second Amendment right. How, if possible, does a defendant get those back? So, yeah, this is a very good question, Liberty, and this is kind of in the weeds, but I think a lot of it's going to depend on your sort of your state. Under VAWA, a misdemeanor conviction for your DV strips your Second Amendment rights. How, if possible, does the defendant get those back? So it depends. So this is a very sort of nuanced question here. So it depends on the states, and it really depends on the state and your ability to expunge a record and restore your rights. So in Arizona, so we're talking kind of about three separate things here. Number one, in Arizona, you've got what's called a motion to set aside your conviction. All right. And the way that law reads, it's 13-905, I think it is. It used to be 907. I think it's now 905. It just changed. So 13-905, if you want to look that up, it'll say that you can set aside your conviction. If you do that, technically, if you read the rules of the law, it says it relieves you of all the penalties and liabilities of your prior conviction. So what does that mean? If you're relieved of all the penalties and liabilities of your prior conviction, you can interpret that how you want to under the VAWA Act, right? You can also use that to sort of make the determination on what you want to do with your gun rights. So this would be like a lower level non-felony offense that exists in the state of Arizona. It's domestic violence. You can't get it expunged because we don't have expungements for that. And it is a misdemeanor offense. So you would file a motion to set aside your conviction. Then you can get into a whole conversation about where that leads, right? And I would speak to an attorney personally about your situation before you make any conclusions on that. That's number one. Number two, in some other states, you do have expungements. And an expungement, different from a motion to set aside in Arizona, is basically a permanent removal of that. It's like it never happened. A motion to set aside a conviction is a little bit different. It did get convicted, but it's now been set aside. So you've got some nuance there. Then you also have a felony restoration of rights, which is a whole third cause of action. So in Arizona, let's say you're convicted of a domestic violence felony, right? It's a third domestic violence offense, or it involves choking or something like that, then it's going to be charged as a felony. If you're convicted of that, you complete your probation, complete any of your penalties, you can come back later. You can have a felony conviction. So then on that, you could do a motion to set aside a conviction and then a restoration of rights and request your firearms back. So sort of three different mechanisms and angles. A lot of it's going to depend on your state law and what they do to deal with old prior convictions. But you can see you can really get into it on that. And you have you sort of have a lot of gray area between the federal laws and a lot of the state laws. And some states are already very, very restrictive on firearm rights. And so, if you get convicted of a misdemeanor in some states, I don't know what they do with your firearm rights. It could be different than it is in Arizona. But it's a good question, Liberty. One that you could really do a lot of deep dive into. So if anybody's thinking about anything about that, I would really recommend you contact a lawyer to detail your situation specifically. We got Sharon says, This story about the people being detained because of software problems, this is as outrageous as the election stuff. It's a denial of people's fundamental rights, no matter how you look at it. And it's all because of software issues. Dump the machines. Yeah, so it's just machines across the board, right? We don't want machines necessarily calculating votes or inmate days in prison, because obviously they're not any good at that. Now, I think that this is probably way bigger than the software thing. I think that this is just general, incompetence, or I would say apathy, right? They just don't necessarily care too much about making this an issue. Yeah, this new thing exists. The inmates will figure it out. If, the squeaky wheel gets the grease, and anybody who's, kind of bitching about this stuff in prison, we'll deal with them. We'll just count it by hand. We'll make sure they get out early. But you got to remember, everybody, this, the people who go through our justice system, they're largely seriously disadvantaged. They have almost no resources. And so there's going to be just a huge population of people in there who are sitting in there that have no need to be sitting in there. And it's our government's responsibility to make sure that they're being cared for and advised properly about these options. And they're not doing that. And they're doing it because it's apathetic. It's too much work. They spent $24 million. Maybe they're out of money. Who knows? But this is just one crack of the facade of what our criminal justice system looks like. It's antiquated, it's bureaucratic, it's inefficient, it's a mess. And we got to do something about it, because there are people sitting in there who shouldn't be. Pinky number 2 says, come on, we in Oklahoma have bigger problems than this. If someone gets on a highway and walks out in traffic, that is suicide. Come on, we in Oklahoma have bigger problems than this. If someone gets on the highway and walks out in traffic, that is suicide. Yeah, I would agree. Ma Fox, if you're okay with this bill, then I have to shake my head at you. As it stands, you have to prove that there was no way to avoid any injury you caused, and that there was a threat to your life. This does go against the idea of civil obedience. This goes against the idea of civil disobedience being standard protest. Yeah, I'm not okay with the bill of just running people over in the middle of the road. I don't care what your position is on protests. That's not okay, right? You want to avoid death and destruction and mayhem and injury at all costs. And the same thing goes for the protesters too, right? It's the same standard. If they're injuring people, that's not okay. If they're launching Molotov cocktails at buildings, that's not okay. Just like hitting somebody is not okay. If they're coming at your vehicle and your life is being threatened, then you have these same self-defense strategies. The same, you can run your car over, whatever. Like, it's the same concept of self-preservation. Those apply. You don't need additional laws to say, yeah, just hit the gas when you're going through. Just hit it. Just punch it. It's ridiculous. You're right on, Mom. We got Fair Dinkum says, do you figure the people behind the Oklahoma proposal would mind if armed protesters defended themselves against weaponized vehicles? Very good question. So I'm going to guess that the answer is a hard no on that, right? I think this is a waste of, it's a political spectacle like we see from a lot of politicians, right? You probably have some people, I'm not saying this, because it's Oklahoma. I'm just saying this in general. You probably have some people who say, run them over, right? Yeah, run them over. All right. I know that sounds good and might feel good, and you might really dislike the protesters and dislike what they're standing for and the cause and all that stuff. And it might sound like, oh, that sounds fun, but it's right. It's not serious law. Maybe it is. It passed like 8-1 out there, but I think your point there, Fair _ Dinkum, is exactly right. What if somebody took this law and took it to heart and said, yeah, I'm just going to run right through these people. I'm late for work. I don't feel threatened. My kid's crying in the background. I got to drop him off at the sitter. I'm not sitting here and waiting for these idiots to clear the road. I'm just going to motor through them. And that person escapes liability, escapes criminality. Now, again, to be fair, we don't have the full bill in front of us. I haven't read the specifics of the law, but I'm going to guess it's not like that. I'm going to guess it's not that you can just, sort of, steamroll through a crowd, but who knows? Liberty or Death says, if I'm driving somewhere and protesters block my way, I will call the police. They start jumping on my car and breaking my glass. I hit the gas. Yeah, I think that's pretty reasonable, right? If they're out there, you just, all right, I'm going to be late. Sucks. Hey, sorry, boss. It was the protesters. Sorry, teach. Liberty, I think you're in law school. Sorry, professor. There are people out there fighting for the Constitution, fighting to protest. Don't get mad at me, right? E. Dantes says, 1 second. Did they just say brandishing firearms and storing Capitol building? I'm not aware there was any firearms brandished at the Capitol. Am I wrong? I didn't see many firearms. I think you're right. I mean, I don't recall seeing many of them. I think that some people did have them. I saw zip ties. I heard about fire extinguishers. I heard about, American flags being used as batons and beatings. But I didn't hear any, nobody got shot other than Ashley Babbitt, but that was by a Capitol Hill police officer. Officer Brian Sicknick, we don't really know what killed him. It started off as a fire extinguisher, but then he died the next day, and they have no cause of death there. And he's already been cremated, so we don't know what those autopsy results show. So firearms being brandished, I think that's probably an overgeneralization. And our last one is from Hack Consulting on the day. This last one came over from locals.com/watching the watcher. It says, Robert, that inmate thing is why we should not try to automate everything. Wish they would promote work ethic instead of barely making the requirements and sucking out all the taxes. Yeah, it's a lot of money, a lot of taxes. $24 million on a system that doesn't work. And they spent a couple more million in order to go and beef it up, and still doesn't work. So now you have people from the Arizona Department of Corrections literally there with a pen and notepad just going, calculate this day, calculate that day, just keep moving on. What do we get for that $24 million? Well, we're not getting justice for it. We're not getting a working, functioning system. And we're certainly not getting any justice for the inmates, for the people who are within the government's own purview, and they're not telling them about this option, and they're not letting them out early, even though the law was passed, signed into law. It is the law now. You may disagree with it, but it is the law. And they're entitled to know about it and to operate under it, and that is being deprived of them. So I think there will be a lot of lawsuits for this thing, as there should be. All right, and so that was it for the questions. I want to thank everybody for them. Those all came over from locals.com/watching the watchers. These are the people, the great people who have signed up and helped and supported the show. Of course, always a big thank you to Miss Faith Joy. We got another one from Ma Fox, the mod. And we've got a lot of people here just kind of supporting us over there. We got Blue Eyed Hillbilly. We got Lady Anderson. We got Lead Shed. We got Rolf77. We got Garka. Let's see who else was in the house today. We got Wise One was in the house. We got Want to Know. We've got I'm a Lemon. We got Echo House. We got Arcturians. We had some new signups over this weekend. We had Aurora's Mom 2021. Welcome. We got Fang 3, welcome to you. We have another one from Jorgen Johnson. Welcome, Jorgen. We got Willie's Driver in the house. Hey, Willie. We got Aussie Andy. Then we've got Sam I Am 256 and Remark 2. They all signed up and joined us over on this platform here called watchingthewatchers.locals.com or locals.com/watchingthewatchers. And so all of those questions that we went through today, that's where they came from. What happens is Miss Faith will put up a live show thread, and so people will just ask questions and sort of communicate over there. Until we get the super chats back, we're getting real close. We can apply for remonetization here in early March. So we're going to go ahead and do that and see if the YouTube overlords will allow us to use some of those features again, because the super chats were fun. So that's it for me, my friends. I want to thank you so much for being here. A couple quick things before we sign off. If you do want to join the Locals community, it's free. If you want to participate, ask questions, and comment, you do have to pay $5 a month in order to support the show. It's like a cup of coffee, right? I mean, it's like basically nothing. And so you can get all of this stuff for free over there if you do want to head over to Locals. All the PowerPoint slides. You can also grab a copy of the impeachment party documents. Those are going away. It's kind of moot at this point. It's moot. We also have the existence system, which is a little personal productivity thing. These are PowerPoint slides, so you can actually just download these and use them, modify them to your own heart's desire. We also share links. Get a copy of my book over there. It's free PDF over there on Locals, or download it on Amazon if you want to do that. Get links, good conversation. Of course, there are great people over there as well, and that is the real reason to join Locals. It's just to get plugged in, because together we're sort of building a little bit of a community where we sort of like to talk about these ideas, talk a little bit more about free speech, and not be so worried about the pillars of the tech world just crumbling down upon us. And so we're doing that over on Locals, and I appreciate all of you who are helping us build that little community. And you're also doing us a huge favor by supporting the show. So head on over there, watchingthewatchers.locals.com. That's the web address. And lastly, I am a criminal defense attorney. And so if you know anybody in the state of Arizona who does need help with a criminal charge in our state, we can help them. We help people clear their records, open cases, close cases, restoration of rights like we talked about today. Basically, anytime you're in trouble with the law, we can help. We help good people find safety, clarity, and hope in their cases, but also in their futures. And so if you trusted us enough to send us a referral, we would be forever grateful, and we'll take very good care of them. We'll make sure that they leave our office better than they found us. And so we would appreciate anybody that you send our way. We'll take very good care of them. We'll be very appreciative of that. So that is it. Promise. Nope. I retract my promise. Last thing, by the way, it is Miss Faith's birthday today. Did you know that? Did you know that? Right back there. It's her birthday today. And so in honor of Miss Faith and all of her tremendous work that she does, it would mean the world to me personally and to Miss Faith if you would just go down into her Instagram. There's a link right here in the description. Just go on down there. Send her a nice little message. Happy birthday, Faith. Hey, you're awesome. Happy birthday. Send that to her. That would be great. And there's also a link where you can go and support some of the work that she's doing. She is in this contest to be a chef, right? Sort of a number one chef for some contest. And last week we talked about, she was like a little bit down in the rankings there, which was a travesty of justice. We talk a lot about injustice on this show. That was mind-blowing. So as a birthday present, a nice little, hello, happy birthday to her would be great. If you want to support the work she's doing, give her an upvote on her Instagram contest, and that would mean the world to me personally. She's amazing. She deserves help. She deserves our support. She is way too humble to ask for any of it. She doesn't like when I do this, but that's just too damn bad. It's my show. So go support Miss Faith. She's awesome. Happy birthday, Faith. And that is it for me. That is the last little plug. Thank you, everybody, for indulging me on all of this stuff. I know it's a long outro. I think a lot of people probably bail out of here 5 minutes ago, but I appreciate you sticking with me if you have thus far. Everybody have a wonderful night. We'll be back here same time, same place tomorrow, 5 p.m. Arizona time, which is Mountain Time. Then we have 4 p.m. in California on the Pacific Coast. We've got 6 p.m. in Central Texas, Texas and Central Time. And then we've got 7 p.m. out on the East Coast. And for that one Florida man out there who's doing whatever he's doing, we'll see you back here tomorrow. Everybody have a wonderful night. Sleep well. Take care, and bye-bye.